safety
Admission item number 1.
construction. Lordship, in compliance with this Honorable Court order dated 13/9/2023, we have filed an affidavit. Roshan.
Sound that's you. Volume the bar. Volume the bar.
Extra pa siya dalo na sa daan ko siya.
Now, what has happened to the hospital? Its function?
It's functioning and it's
But how is it being taken care of as regards the parking?
you said
That problem has already been solved, Yajib. In fact, copy that.
It doesn't mention anything about parking.
Yes, Yajib. In the building itself, in the permit, in the plan, the parking area is already included.
But where is the parking?
In the building itself, Yajib, the parking area is already in the building plan.
So it will be there in the approved plan.
Yes, Yajib.
So you
It's
have to build
included.
it on-
The parking area is included in the. Yeah.
Because the instant PI was taken up by this court, taking into account, more particularly if we see the order of 1312, where to be used as a hospital, namely Agap Multi-Speciality Hospital,
Yes.
does not appear to have any parking space for four-wheelers. Now, you have not started the hospital, or have you?
Even on the date the matter was taken up so moto, the hospital was already functioning. And one floor has been reserved for parking, the road level floor.
But in that floor, I think you were also using it for X-ray machines and all
That
these
has
things.
been dismantled, Your Worship.
So that has been stated out there in the affidavit.
Yes, Your Worship.
And what does the state have to say on this aspect?
Lordship,
What do you have to say on this aspect as regards the parking?
Lordship, it's
Is it in conformity with your building
yes,
bylaw?
yes, Lordship, it's as per the permission of the government.
No,
also
not
as
the
per the
permission,
agreement.
as per the building bylaws. You see,
I believe AMC can
it has to
clarify
be
that
on the
point.
basis of how much footprint there would be compared to the area where it is, the hospital is being set up.
I believe the municipal council,
AMC.
AMC can clarify that point, Lordship. It's their regulation, Lordship.
My lord, when this matter was taken up, the area for parking was used for the purpose of X-ray machines and some laboratories, and there were no parking space at that time. And this matter was taken up, and thereafter, the MC took some strict actions against the hospital owners, and they have demolished their X-ray rooms and their lab at this stage. So now the parking area is sufficient as per the rules, my lord. What parking?
Let's see the rules.
Regulation naman hindi hotel to. In affidavit.
And what is this permission being granted? This happened in 2024.
Vertical extension, Your Worship.
There is further vertical extension, but whether it again also includes further parking area.
No. Your Worship, we are just tenants. The owner of the building is respondent number 10. And
You are the hospital.
we are the, yeah. We have,
It's a different thing. You are a tenant. Are you going to vacate tomorrow when you, the owner? Who is the owner?
and now the permission has been granted for medical institution also.
Owner is he,
Yes.
and you are the tenant.
We are the tenant. In fact, Your Worship, the Honorable Division Bench, initially this problem was entertained, and now now it's regarding traffic
What are the
management.
building bylaws? Let's see. Have a copy. Because the higher is the building, if you are giving a higher, more vertical extension of the building, then obviously there has to be more commensurating parking area. You had the parking area and the municipal authority were satisfied at that point of time, taking into account that the building was of this height. Now, if it is the height has been given extension by this, what do you call this, building permit, and made it the G+9, then obviously, what was when the PIL was taken up sumoto? What was the height of the building then?
Your Worship, the
Regulation.
yeah, no, Your Worship, the point involved was at that stage, but now the Honorable Division Bench has carried on further to different matters regarding traffic management. And the problem regarding the building occupied by the hospital has been already solved. And there's no more problem with the running of the hospital in the said building. Because the floor on the main road level is being used as a parking area, and the hospital have also taken on lease a parking area next to the hospital in another building.
So are those things stated in the affidavit?
Yes, Your Worship.
Where?
Your Worship, in fact, last year, April. Yeah. April 2023, respondent number 11, affidavit.
'18th April. Oh, this is by respondent number 1.
April ito, 2012.
Definitely poor blank.
Masa kan receive ni kan ni file down.
Oh, hey, hey, no,
18 for down.
23 is open here. Yeah. Compensation. Sorry.
23 kan.
April 23. Yeah. Traffic management. Oh,
Yeah, got the building bylaw. Wait. Where's the parking thing?
amen.
Institution. Hospital, institution building, institution.
Institutional area maximum floor area ratio is 2.
Well, I mean, oh, 25 bracket 6. Oh, 44. Page 34. Oh. 34.
And how many beds you are having?
53.
How much?
In the 53 beds, yeah.
And how much parking area now?
Lordship, in fact, if I may take your Lordship to the affidavit filed by us on 18th of April last year.
18th April, somebody else filed it.
In April 2020.
Institution, 15 beds. Sons.
17th April.
25, 6.
Affidavit filed by respondent number 10.
Beds.
You are 10?
I'm 11 years.
You have filed it?
Respondent 11 years.
So she is possessing landed properties and so and so that all the.
Country admit.
Parking space over here and this space here. Parking space over here.
We find only 18th April's affidavit is of respondent number 1.
Respondent number 10 kami naman yun.
Ano ito?
So, as of now, there is no parking for the patients. The patients don't park outside the hospital.
No, Your Worship. We have taken on rent parking area next to the hospital, and we have also enclosed the lease agreement. And as per the directions of this honorable court, the X-ray area was also demolished, and now the whole area is used for parking. And we have also enclosed photographs in the affidavit filed by us.
But these were all of 2023.
Yes.
At that point of time, there was a discussion going on that you are, at that time it was G+6.
Yes.
Now with G+9,
Yes.
what will be the other fallout?
Your Worship, to take care of that, Your Worship, that is why the parking area, which was the ground floor along the main road level, if that is not enough, we have already taken on lease further parking
That I
area.
understood,
Yes.
but these happened in 2023.
Yes.
These affidavits are of
20,
2023.
23, yes.
We are concerned on 4/1/2024, there was a permission being granted for construction of G+9.
Yes.
Now with this extension of another 3 floors, the footfall would be much more. Obviously, you are going to use it. So under such circumstances, how are you taking care of those parking?
Your Worship, as on date,
Have you made any, because you made the arrangements only for G+6. That is 4 four-wheeler parking and 10 two-wheeler parking in your place, and the remaining out there, 10 four-wheeler parking and 40 two-wheeler parking in the adjacent area. But this is of 2023. At that point of time, you did not have the G+9.
the number of beds has not been
It
increased.
is not a question of the beds.
Yes.
If you just use it only for the purpose of diagnostic, what will happen to the traffic jam?
Your Worship, as on date, there's no complaints against us that it's causing traffic jams.
If there was no complaints, then why was the PIL at all moved? It was taken up sub motu, taking into account that there is a dirt. What do you say, Amicus?
My lord, at that point of time when the PIL was instituted, as per their submission, at that point of time at the garage there is an X-ray room, and during that time there was quite a lot of
Tell
traffic
me,
congestion.
as of now, how is the parking situation in that hospital? Because you see, tomorrow you may have a
Yes, my lord.
9-story building.
Yes, my lord.
If we just go as per the building bylaws, against 15 beds, there is the requirement of only 1 parking. But how do you take care of a situation where the most of the building is used as a diagnostic center? Lot of patients comes.
As per their submission, my lord, one floor, it is true that one floor is designated
Has the
fully
police
for
out there, has the traffic out, police out there has put any signboard that no parking outside the hospital? That should be stopped. Then we'll see how it works.
one
Isn't
thing,
it? What do you say?
one thing I
Because you see, there is a requirement of having a facility with proper parking. You are today going to have a G+9. If we just go as per the building bylaws, against 15 beds, there's one parking.
Yes, my lord.
Now they may have only, they are saying that they are only having 53 beds, which means they need only 3 parkings. That's all.
Yes, my lord.
But against 53, there might be attendants or persons who are going out there to meet them. Where will they park?
According to them, my lord,
I'm asking you because you are an amicus. You are also a resident of Aizawl. Tell
yes,
me,
my lord.
is it conducive?
As per their
Taking into
submission,
account that most of the it is absolutely a traffic menace in Aizawl.
since, my lord, since they are willing to rent out another building adjacent to the hospital, I think they are willing to do that, to designate the parking. As per their submission, they have made a lease agreement.
Gente, i paramita ang G+9 ang parking area lang ang ang drawing kaya nila ang drawing kaya nila so malam siya sila moro ang drill silang sila hindi nga kan pakain ni ang drawing ko na may nang katakang siya as siya so pati sila din mo ito ni Ayan. Hindi pa po hindi kan lupa. Kan siya.
So Malhotra, does your hospital do outpatients?
Your ship, I'll have to find out here.
If your hospital does outpatients, then you should, if we go only by the parking,
Yes, yeah.
then the parking has to be only commensurate with the beds, then only it can do only inpatients. But if it does outpatients, then obviously it cannot with this type of parking.
Yoshiba, if I may let the building plan.
And
submit.
more particularly after G+9,
Yes.
because there is no affidavits as regards this particular document which you are placing, that you have been granted a permission.
Yes.
And along with
In fact, it is the owner of the building who has been granted the permission. Let the owner of the building submit the building plan. That will show, that will be clear the picture also. Because this is just the permit.
Mr. Malhotra, have you seen the affidavit of the owner of the building, 17th of April 2023? He says that I have given everything to you. You have to pay, you want another 3 story to be made. Then,
Your ship, as on date, there's no traffic problem, your ship, because we have taken on rent space for parking, and the road level floor is reserved for parking. Even the X-ray room has been dismantled, your ship. Now,
which area is this?
yeah, it's Chan Mari.
That, which exactly is the area? If we go
Near-
towards
near the-
near Raj Bhavan,
No, your ship.
Near the junction, my lord, near the junction.
near?
It's near the junction, approaching Chal Marikol.
If you do one thing, you bring on record the approved plan as well as this particular permission. I think it would be better of a local judge taking up the issue properly, because they will be knowing exactly what is happening. This is better. Because we are not exactly trying to know where it is. If it was in Guwahati, we could have very well known where the traffic.
In fact, your ship, the Honorable Division Bench has gone into some other issues now.
Yes, I've seen that.
Yes.
So how much parking, what is happening.
so,
Yes, I've seen out there on this last 4-5 days I'm here, it is a traffic jam. And the parking is done anywhere, everywhere, it's wherever they feel like. And the roads being narrow out here,
Yes.
it's
It's a problem here, everyone's facing. But I think the government is also taking steps. Lots of new buildings are coming up where there are, paid parking areas. Even private owners, and with help from the government, and they're building buildings where the certain floors are reserved for parking.
that too one has to do, taking
Yes,
into
yes.
account the amount of construction which is there in Aizol.
But my humble submission, Your Worship, with regard to this hospital, the parking area has been solved.
Can't be solved.
That is why the Honorable Court has gone into some other.
No, in fact, nobody must have pointed out what is going to happen with the outpatients. If I was sitting with another local judge, it would have been much better. He would have known exactly which is the area. Anyways, Mr. A.R. Malhotra, the Learned Counsel, appearing on behalf of respondent number 11, submits that the respondent number 10 have been granted a further extension of have been granted a permission to make a vertical extension of the building wherein the hospital is presently functioning. It is apposite herein to mention that earlier the hospital was functioning the hospital was functioning in a building which was G+6, and now with the present permission granted on 4/1/2024, the permission of the building have been given for G+9. However, the approved plan and wherein the parking areas, additional parking areas or any, have not been placed before this court. So considering the above, we direct the respondent number 10 as well as the respondent number 11 to bring on record by filing affidavits as regards the fresh permission so granted as well as the approved plan. The council appearing on behalf. Here you are having a Aizol Municipal Corporation.
Yes, yeah.
The council, the Aizol Municipal Corporation. The learned amicus curiae also shall make necessary submissions on the next date as to whether with the extension of the building vertically would it commensurate with the present parking
Area. Please.
Parking made available by the respondent number 10 and 11. It's the matter again on 11th of November. We'll have it on 13th of November.
Obliged.
Item number 2.
Yes, give me the Lokayukta.
Let me get the Lokayukta Act in the PI itself. Sorry, petition itself, I have annexed.
Yes.
Page 76 is the Lokayukta Act, ma'am.
Okay, tell me. First, let's go on the position of virus.
Yes, ma'am. Then let us first see the, my lord, Lokpal Act and Lokayukta Act enacted by the central government, ma'am, Union Parliament. Yes, ma'am. That is Lokpal and Lokayukta Act, my lord.
Yes, tell me.
My lord, at the object clause, it says, my lord, an act to provide for the establishment of
Yes.
this is of Act number 1 of 2014, an act to provide for establishment of a body of Lokpal for the union and Lokayukta for the state to inquire into the allegations of corruption against certain public functionaries and for matters connected therewith or incidental thereto. My lord, that itself says it's a body of Lokpal. Then my lord may kindly come to, it will be of some relevance, my lord, at later point of the hearing, my lord. Section 1, subsection 4. It shall come into force on such date as the central government may by notification in the official gazette appoint. That will come later on, but just for your lordship's notice, my lord. Then subsection 2, subsection 1b. Chairperson means the chairperson of the Lokpal. Then my lord may kindly come to definition clause again, my lord. Section 2, subsection 1e. Complaint means a complaint made in such form as may be prescribed, alleging that a public servant has committed an offence punishable under the Prevention of Corruption Act 1988. So it has to be a complaint as may be prescribed. Then, my lord, G, my lord, investigation. Investigation means an investigation as defined under clause H of section 2 of the CRPC 1973. Then judicial member defines, my lord, means a judicial member of the Lokpal. Lokpal means the body established under section 3. Then member means a member of the Lokpal. Then preliminary, M, my lord, preliminary inquiry means an inquiry conducted under this act. Then S, special code means,
But why are we reading this?
because this will come, because we are making a comparison with the Mizoram Act, my lord.
No. Why are we reading? This is for Lokpal.
Yes, this act is not Lokpal, it's Lokpal and Lokayukta Act.
No. Kindly see part. It is in part 2.
Yes, madam.
Lokpal for the union.
Yes, madam.
So let us see what is there for the
Lokayukta is section 63. Section
This is no reference or relevance out here. Let us see where is the Lokayukta.
It is section 63, madam.
Huh?
That is a delegated legislation to the state government, madam. Section 63.
So this has no relevance out here. Where is the Lokayukta thing?
Madam, this has relevance because, my lord, the Lokpal. Okay, my lord, let us go to section 63 for a moment, madam.
Wait, let us first see why.
Section 63. The act is Lokpal and Lokayukta Act. Section 63 says,
Lokpal and Lokayukta, we understand. Let us see.
that's the last section, my lord, part 3.
This is all as regard Lokpal. Lokpal is for the
Union. It is for the central government, my lord, and for the state it is 63, section 63. Just before the schedule, my lord.
Part 3.
Part 3, establishment of the Lokayukta. Every state shall establish a body to be known as the Lokayukta for the state, if not so established, constituted or appointed by law made by the state legislature, or to deal with complaints relating to corruption against certain public functionaries within a period of 1 year from the date of commencement of this act. So, my lord, Lokayukta, which will deal with the complaints for the state services, will be constituted by the state by way of an enactment.
Yes.
Then, my lord, that is why, my lord, for the union, suppose, my lord, my colleagues, they are serving in the union, I am serving in Mizoram, my lord. There is a complaint against me. The manner in which it is treated, if it is not the same in the manner it is treated for the central service, my lord, there is discrimination, my lord. Here is a case also, my lord, I will come to that, my lord. The manner in which I was treated, my lord, is not the manner in which my colleagues are being treated, my lord. So that's why, my lord, there has to be some resemblance with the Lokpal as well as with the Lokayukta, my lord. Their fields are different, my lord, but the authority and the power is same, my lord. It is for the central, it is Lokpal is for the central services and it is for the state services. May I take your lordship to section 3 of the Lokpal Act, my lord.
Subject to the other provisions of this act, the Lokpal shall inquire
My lord.
or cause an inquiry to be conducted in any matter involved in or arising from or connected with any allegation of corruption made in complaint in respect of the following, namely any person who is or has been a prime minister,
Yes, my lord.
provided law shall not inquire into matters involving or arising from or connected with any allegations against the insofar it relates to so and so. Any person who has been a minister of the union,
My lord.
any person who is or has been a member of either house of the parliament, any group A or group B officer or equivalent of above from the amongst the public servants defined under so and so of the Iman, group C and D officials or equivalent from amongst the public servants and Iman, any person who has been a chairperson of so and so, provided so and so.
So, my
Now
lord,
tell me, under what authority this act was made?
apparently, my lord, entry 2 of list 3, my lord, concurrent list. That's a criminal procedure part, my lord.
So therefore,
So therefore, it's a concurrent list subject, my lord.
so
If it is violating PC
So
Act,
here the while concurrent list, it has been done.
my lord.
So under such circumstances, the union had categorically dealt with only in respect to those officers or prime minister or prime minister or any ministers out there who are falling under the union. They have not touched anybody who
Yes.
falls within the state services.
Yes, my lord.
So under such circumstances, and section 63 further makes it clear that it is absolutely within the jurisdiction. So there is no repugnancy with 254.
True, my lord.
Then what is
To
wrong?
the,
Why
to
should
the
we
extent
look
of the
into
authority of the state legislature to enact, I am not questioning that, my lord. What I am questioning, in the process, my lord, they have violated PC Act, they have violated section 197 CRPC,
We are not on that.
because that is one of my challenge, my lord.
No, let us not go on that aspect. We will go into that aspect later on. But how do you challenge the virus?
Because, my lord, will kindly see, for one example, my lord, there is a provision for causing an inquiry. If a complaint is received by a Lokayukta, he will take a call whether inquiry is to be caused or not. That means, my lord, he can also take a call, no inquiry is needed. If an inquiry is caused, there is a report of inquiry.
Again, Mr. Goswami, you are coming into the facts. First, let us go into the question of virus.
Yes,
Whether the question of virus at all arises or not.
here, my lord,
That is why I
Here, my lord, will
on
see-
the last occasion put you to your specific question.
Yes, ma'am.
Are you serious on the virus?
yes, my lord, because
We'll look into the other aspect as to whether there has been they have followed on section 19, 1, 2 and 3 in a manner which is provided under the act. That is another aspect which we will look into. First, therefore, I was asked you whether you were serious with the virus.
yes, my lord. But on the issue of virus, my lord will kindly appreciate one thing. Section 3 has Lokayukta Act, Lokayukta Act, Mizoram came into force in 2014. It was enacted in 14. So it was again amended in 16. Thereby, my lord, the necessity of having another member or a judicial member has been completely done away with, my lord. Under the Lokpal Act, if we make a comparison, Lokpal Act,
But he did not say,
yes, my lord.
they did not say that the state government's power, because the power is there.
But power doesn't mean the power to do anything, my lord.
No, the power is there.
Power is there to constitute a
It
committee.
cannot, unless there is the question of repugnancy does not arise in view of the clear mandate of section 63.
Section 63 says state will enact a law.
Absolutely.
That
they will
doesn't
do
mean
it there.
state will enact a law. A person, sole member, non-judicial member, chairman has been entrusted with the power even to inquire against the present chief minister, my lord.
Yes.
Not to speak of me, my lord, I'm a small person. So this kind of unfettered jurisdiction to a non-judicial member who is having some amount of quasi-judicial power, my lord. There are judgments to indicate, though it was in the context of tribunals, There are judgments which indicates when there is a, why is the requirement of a judicial member? In a committee, in a bench, why there should be a judicial member along with an administrative member, my lord?
No, that those judgments on a different line as regards to the administrative tribunals or all these tribunals where there is a
Because
requirement for a judicial member.
maybe, true, my lord, they are exercising completely judicial functions. Here is a
Because
case,
here they are not functioning judicial functions.
it's not a judicial body, but it has some quasi-judicial functions, my lord. My liberty is at stake.
Well, then in that regard, all the deputy commissioner also sometimes exercises the quasi-judicial
My lord,
authority.
Deputy Commissioner, in my case, cannot grant me or withhold my lord prosecution sanction. Deputy
no,
Commissioner
no.
cannot dictate.
No,
that
no,
they are-
I'm not on that. So the question is, on the principle that if there is a quasi-judicial authority, he has to be a judicial member or have judicial knowledge about it, does not arise. Anybody, a person who is asked to exercise a power which affects certain rights would be exercising a quasi-judicial authority. That is why they are mentioned as quasi-judicial. Here also, the Lokayukta or the Lokpal does not exercise judicial functions. They only do quasi-judicial. Whereas those judgments, you are referring to Justice Ranjan Gogoi's judgments in the Supreme Court, those are judgments
Was purely in
wherein
the
in
context of
respect to
tribunal.
that these are administrative tribunals where there is a requirement of having a judicial.
But in the process,
these
my
are
lord,
judicial orders.
in the process, the Honorable Apex Court has also, my lord, explained why a judicial member is required. Here is a
No,
case,
it is
the-
in those cases.
here is also a
Nothing
case, my
here.
lord will see, Principal Act came in with the judicial members. That has been done away with now, my lord.
Okay.
My lord,
If
kindly,
that is the virus question, then let us go into the facts.
my lord,
not
allow me some time, my lord.
We are not satisfied on that.
No,
Now
let me
come
at
to the
least-
facts.
Let me at least submit my points, my lord.
Yes, we have taken it.
My lord, may kindly peruse Lokayukta Act 2014 for a moment, my lord. Mizoram Lokayukta Act, my lord. It's there in page 76 of the petition, my lord. Page 76 of the writ
Yes.
petition, my lord. The relevant page is at page 82, my lord. Relevant section is section 3.
3.
Section 3, my lord. Body of Lokayukta. As from the commencement of this act, there shall be established in the state of Mizoram by notification in the official gazette a body to be called the Lokayukta who would have administrative, financial and functional independence from the government. The Lokayukta shall consist of a chairman who is or has been a chief justice of the High Court or a judge of the High Court or a person qualified to be a High Court judge or a person who fulfills the established eligibility specified in clause A and B of subsection 3 of this section, and such number of members not exceeding 3, including the chairman, out of whom one shall be judicial member. My lord, original prescription was 1 judicial member. Out of 3 member, 1 judicial member. 3, a person shall be eligible to be appointed as a judicial member if such person is qualified to be a High Court judge or has a vast knowledge of law and experience in the judicial matters or courts. B, as a member other than a judicial member, if he is a person of impeccable integrity, outstanding ability, having special knowledge and expertise of not less than 20 years in the matters relating to anti-corruption policy, public administration, vigilance, finance, including insurance, banking, law and management. Now in my lord 2016, this act came to be amended, my lord, which my lord finds at
113, 111.
111, my lord. 111. This amendment, my lord, will see. Amendment of section 3. In section 3 of the Mizoram Lokayukta Act 2014, herein after referred to as the Principal Act, in clause A of subsection 2, after semicolon, the word and shall be substituted and the words and or if appointed. So if we now come back to section 3, subsection 2, my lord.
In clause A.
The earlier word and is now substituted by and or if, and oblique or if appointed. If we now read, my lord, subsection 2A, it will be read like this, my lord. A person who is or has been a Chief Justice of the High Court or
So what they did,
After,
that the Lokayukta shall consist of a and oblique or such member or members not exceeding 3, including chairperson.
no, not before, not like that, my lord.
No. First, they have substituted the word and at page 82
With or if appointed.
with and oblique or.
If appointed, my lord, you'll see if appointed is also added.
By and oblique or.
Not only and oblique or, it also includes if appointed. My lord, will see the amendment act, my lord.
And it.
The words and oblique or if appointed. So if we now read is like, it will be like this. So and so and or oblique or if appointed, such number of members not exceeding 3, including the chairman, out of whom one shall be a judicial member. So
That our chairperson
that plurality of our body is gone, my lord.
shall be eligible to be appointed Then
Then, my lord, if we now read next amendment, my lord, page 111. Subsection 3 shall be substituted by the following names. 111, my lord.
Yes.
2. Subsection 3 shall be substituted by the following, namely, 3. A person shall be eligible to be appointed as a chairman or a member other than a judicial member if he is a person of impeccable integrity, outstanding ability, having special knowledge and expertise of not less than 20 years in the matters relating to anti-corruption, policy, public administration, vigilance, finance, including insurance and management. Then, as a chairman or as a judicial member, if such person is qualified to be High Court judge or has a vast knowledge of law in judicial matters of court. So now subsection 3 is to be read like this. Earlier subsection 3 Earlier subsection 3 was, my lord, a person shall be eligible to be appointed as a judicial member if such person
so now there can be one person.
yes, one person that to non-judicial member. But why I am saying Principal Act acknowledges the requirement of a judicial member.
Don't come.
Principal Act means by 2014 Mizoram Act, my lord.
Yes.
At least 1/3. Well, if we go to Union Act, my lord, it is 50, not less than 50%.
Forget
Union
about
Act says
that.
50%
Union
judicial
Act,
member.
Forget about that. We are not concerned with the Union Act because Union Act categorically takes out the state out.
Takes out the states out, but officers like me are deployed in union as well as in state, my lord.
Huh?
Officers like me are deployed in union as well as in state, my lord. So equal protection is also, and I'm entitled, my lord. That is why, my
What
lord,
is the equal protection for?
for example, my lord, to grant go ahead approval with the investigation, there has to be a bench comprising of a judicial member in respect of union services, my lord. In respect of me, it is done away with, my lord.
Now, just for example, let us take into account there was no Lokayukta. Then what?
Then, my lord, directly PCI can CRPC, my lord. Direct prosecution sanction under 197.
So is
under
it
section
required? Is it required that in all cases where a corruption case is there against a person in services, the Lokayukta has to be involved?
No, it is not required. But if it is involved, my lord, I am entitled for some certain procedural safeguards, my lord. I am entitled for certain procedural safeguards.
There is no procedural safeguards out there.
Yes, prosecution sanction is a procedural safeguard, my lord, because sanction may not be granted. It's not that sanction is
Look,
has to be granted.
you have to, you see, when you are challenging an act, you have to show that this state, there are two reasons. One is there is a violation of the fundamental rights. And second, the state doesn't have the power. These are the two grounds you have to challenge. Now, the state has the power in view of entry. It is there in the list 3. It has the power. And the question of repugnancy does not arise because the Lokpal and the Lokayukta Act categorically takes out the state Lokayukta outside. So 63 takes it out. So jurisdiction is there. So it is only on the question of Article 14.
And my lord, PC Act and CRPC also, my lord.
PC Act, how
For
does it
example, my lord, PC Act, after the amendment, brings in, my lord, section 17A, which says even for a central service person, before investigation, there has to be sanction. That is not to be found here, my lord. It is completely waived, my lord. PC Act says section 19 prosecution sanction, it is completely waived. In respect of central government, my lord, prosecution sanction, power of prosecution sanction has been granted to the Lokpal. Here
what does the Lokayukta do?
Lokayukta don't have to go for prosecution sanction. Even
No. What does Lokayukta do? What is the function of a Lokayukta?
Lokayukta will, my lord, cause preliminary inquiry. He will direct, on the basis of report, he will direct investigation. On the basis of report, he will direct filing of charge sheet. Then
Let us see. It is only recommended.
it is recommendatory.
It is only lower recommendatory. You cannot say.
For example, my lord,
sanction not necessary.
let us
No
go to
sanction
section-
or approval of any authority shall be required by the Lokayukta for conducting investigation by any agency in respect of cases investigated by any agency on the direction of the Lokayukta under section 197 of the IMAN or under 19 of the IMAN, as the case may be, for the purpose of making preliminary inquiry or investigation by any agency.
Or into
Now,
any
filing
complaint.
where after conclusion of the investigation by any agency, the finding of the Lokayukta discloses the commission of an offence under so-and-so relating to corruption of so-and-so, A and B and so-and-so, the Lokayukta may file a case in the special court and shall send a copy of the report together with its finding to the competent authority. Transfer to the Lokayukta powers of the law to initiate suo motu action to exercise demand, to prosecute the accused before the special and also to recommend punishment of disposal and so. It may be executed by the appointing authority with evidence in the year of non-execution of the ensure the integrity of the
If my lord peruses section 22 for a moment, my lord. Section 22, if I may take your lordship, page 93 of my bid. Why I am trying to take recourse to 2013 Act, my lord, Central Act. There are certain reasons, my lord. If I may take your lordship to the PC Act, my lord.
We are at the stage of 20B.
20. No, man. We are at the stage of 19.3, man.
No. The 19.3 has already been done as per you.
My lord, 19.3 has.
You say that 19.1 and 2 being
Not-
not
not done,
complied,
and-
he has gone into 19.3.
And 3 is being erroneously done, my lord. 3, my
A
lord.
bench consisting of at least 2 members of the AR shall consider every report submitted by the AR for inquiry and so, and after giving an opportunity of being heard to the public servant, decide whether
This
there
has not been
exists a
done.
crime and make recommendation to proceed with one of the following: investigation by an agency, including IMAN, any appropriate action against their concern, closure of the proceedings against every player. So we are at the next stage of 19.3.
19.3, I am time and again reiterating before the authorities that I have not been granted with the reasonable opportunity of being heard. The order passed by the Lokayukta indicates that since you have been orally heard, there is no requirement of giving you a notice, no requirement of giving you an inquiry report, no requirement of giving any document. So for his understanding of reasonable opportunity of being heard is physical hearing, my lord. That is where, my lord, again the need of a judicial member comes in.
That will take care of.
Section 20,
That will take care of.
my lord will kindly peruse section 19 of PC Act. Why, my lord, Central Act has some connection with the State Act, my lord?
No. That is nothing.
That has many things to do, my lord. My lord, kindly peruse one.
These are questions to be very well agitated in the Supreme Court, not here.
But-
Here
but-
we are only on
Well,
9.
at least, my lord,
No, nothing.
with due respect, my lord, Supreme Court, I cannot go and say that I have waived all my rights of argument, my lord.
No,
Section 19 for a moment, my lord.
We have looked into it. You see, the question of virus does not arise or challenging virus. Here, your case is, which I could find out, is there was a complaint being made by some DC of some district, wherein you were earlier your successor
My success.
to the chief secretary. The chief secretary carried out some investigation through the ACB.
Send it to
ACB then
Lokayukta.
submitted a report which was forwarded to the Lokayukta. Lokayukta thereupon issued you notice, and you have on various occasions asked for various documents which were not given to you. And it is under such circumstances you have come before this court.
Yes. And while coming, my lord, I could sense, I could feel, my lord, because it's being manned by a man with no judicial experience. This has happened, my lord. Section 19 PC Act for a moment, my lord. Section 19 PC Act, my lord.
Now, if a 19-3 order is passed, what is the order that can be passed in
They will,
19?
they will pass an order to go for investigation. That means I am exposed to even arrest, my lord.
Huh?
Even I am exposed to arrest, my lord. I can be arrested.
Now, investigation by any agency, including any special investigating agency,
Any criminal
action
agency.
against the imam by the competent authority, disclosure of the proceedings against the public servants.
Yes. Any criminal agency, investigating agency, my lord.
Yes.
Sections 19 for a moment, my lord. It was amended after the Lokpal Act, central government, my lord.
Yes.
Section 19, previous sanction necessary for prosecution. No court shall take cognizance of an offence punishable under section 7, 11, 13 and 15 alleged to have been committed by a public servant, except with the previous sanction, save as otherwise provided in the Lokpal and Lokayukta Act 2013. So Lokpal and Lokayukta Act provides a different manner of sanction that has to be followed, otherwise it is to be followed, my lord. So this sanction, my lord, let us see, my lord, how Mizoram Act has dealt with, my lord. That is, this PC Act, my lord, is to be in tune. This amendment is to be in tune with the Lokpal Act as well as PC Act, my lord.
But here it does not include the Mizoram Act.
That is very much meaning thereby, my lords. We have to, state has to follow the Central Act, my lord, because Mizoram Act in its own, my lord, cannot deviate from the PC mandate of PC Act, my lord. Mizoram Act, my lord, all are in the concurrent list, entry 2, my lord, criminal procedure. Mizoram Act on its own, my lord, cannot make a law bypass deviating section 19, my lord. That is why section 19 has been amended, taking into note, my lord, the Lokpal Act has already come in. That will take, my lord, that will look into the sanction issue, and that has to be in, the state act has to be in parity with that, my lord. State Act has to be in parity with that. If we now, my lord, see the Lokpal Act, my lord. Look, my humble submission, my lord, otherwise the Central Act would have read as, my lord, Lokpal Act 2013. It has used the word Lokayukta, though.
No, the name of the act is there. Can't help it.
No, I'm not saying that, my lord.
Don't come up with that.
Name of the act says Lokayukta, that though it's a delegated legislation to the state.
The act is very clear, the Lokpal and Lokayukta Act.
So the word Lokayukta is also used, which is for the state. So Lokayukta has to be, it has to be in tune with the Lokpal, my lord.
So, Mr. Goswami, are you challenging section 19 of
Yes.
the
Yes.
Prevention of Corruption Act?
I'm not challenging that.
Then,
I'm
without
challenging.
challenge to this, how do you
I'm happy with that, my lord.
No.
I'm not happy with section 22 of the
No,
Lokayukta Act, my
no,
lord.
no, no. How, without a challenge to section 19, how is it?
I'm agreeable with that, my lord. I
No,
cannot.
because section 19 only puts an embargo in respect to Lokpal and Lokayukta Act 2013. So, under such circumstances, when section 19 did not use the words
Lokayukta.
as regards the state legislations to be made in terms with the entries in the concurrent list, then under such circumstances, this section 19 may be bad for not taking into consideration or giving a differential treatment in respect to the state or servant. But as regards the other one, but as regards the state, there is no mention. So without a challenge to section 19, how can you succeed?
There is no mention, but does it, my lord, will it mean that, my lord, state is empowered to bypass PC Act, my lord?
No, it is not the question
Then
of
section,
bypassing.
then section
No.
20 of PC of their act goes, my lord.
No, Mr. Goswami, the question of bypassing the state, the central act, the state, the Prevention of Corruption Act does not arise.
It arises, my lord. Section
No.
22 for a moment, my lord. Section 22 of
Of?
Lokayukta Act, Mizoram, my lord.
Then what does it say? This sanction not necessary.
Not necessary.
Absolutely.
Then,
because
madam-
it would have been necessary had they put there the state law.
But then it will amount, my lord, that in respect of state
Therefore,
service,
I
my
was
lord,
asked, therefore I put you the question, did you challenge section 19 of the
I am not challenging it because, my lord, in my understanding, Lokpal and Lokayukta Act, when it mentions about Lokpal and Lokayukta Act, it also includes, my lord, the Lokayuktas will also follow that act, my lord. Section 22 for a moment, my lord, Mizoram Act.
read it. No sanction is required.
No sanction is required, my lord.
Or approval of any authority shall be required by the Lokayukta for conducting investigation by any agency in respect of cases investigated by such agency on the direction of Lokayukta under 197 of the CR or 19
Section
under
19
remand, as the case may be for the purpose of making inquiry. It would have been in violation to 19 had 19 included the state legislations.
My lord, state, my lord, let us now go to affidavit of state. They themselves admitted. Before that, section
Therefore,
17.
you should have challenged.
No, I am not
section
challenging because I am happy with that, my lord. I am not happy with the
Now,
Mizoram Act.
now we are happy with the other arguments. Now come to the final argument.
No, my lord, will kindly allow me 2 minutes time, my lord.
You
Section-
don't want, are you going to say that you don't want to argue on merits?
Yes, I will argue on merit because my lord said that my lord will go look in.
Mr. P.N. Goswami, we'll dictate the judgment now.
My lord, kindly allow me some time, my lord.
Kindly come to that point, main point, where it is 19.1, 19.2 and 19.3.
That is on merit, my lord, since my lord
Come to the
indicated
merit, others we are not successful.
one argument, my lord, last one argument. Section 17A PC Act, my lord, for just my request, my lord, one argument. Section
You
17A.
should have challenged section 19
Section 19, my lord,
of the Prevention of Corruption.
PC Act section 17A, my lord, will kindly see.
Because section 19 at best means you may say that yes, they have, in respect to the same thing, they are doing it, means they are giving a differential treatment, and as such, an officer which is there in the, even in the state, because if you see 19.2, I don't know, 1B,
My lord.
19.1b in case of a person who is employed so as the case may be at the time of commission of the alleged offence in the connection with the affairs of the or is not reviewable save as it with the sanction of the state government of Iman. So under such circumstances, this person who is employed out here in the state services also, they would require the compliance with the sanctions with the as provided in the except with the previous sanction as provided under the so with this previous sanction of this it is required, but in respect to the state legislation there is no mention.
That is why, my lord, state legislation is bad, my lord. It is,
The state legislation is not bad.
it's bad because it is violating PC Act, my lord, concurrent list.
No,
State repugnancy, my lord.
it would have been bad had it been mentioned here.
If assuming, my lord, nothing is mentioned here, my lord. If the state law violates 19, it's bad because
How it
repugnant.
can be violating 19? Because if it would have violated 19 had there been the inclusion of the
My
state
lord, my
law.
lord has already indicated this act has nothing to do with state act, my lord. So this act has been taken note of in PC Act. State Act has to take note of Section 19, my lord.
How?
Because, my lord, we are protected under Section 19. That's prosecution sanction, grant or not grant.
Anyway, then come to 17A.
17A, my lord.
Yes.
PC Act 17A says, my lord, no police officer shall conduct any inquiry or investigation into any offence alleged to have been committed by a public servant under this act, where the alleged offence is relatable to any recommendation made or decision taken by such public servant in discharge of his official functions or duties without the previous approval, in case of a person who is or was employed at the time when the offence was alleged to have been committed in connection with the affairs of the union of their government, in case of a person who is or was employed at the time when the offence was alleged to have been committed in connection with the affairs of a state of that government, in the case of any other person, the authority so and so. So, my lord, there has to be a prosecution sanction prior to inquiry and investigation. Well, to that effect, my lord, what the state government has come up with, my lord, in their affidavit, my lord, they have admitted, my lord, they are amending it. They have admitted in the affidavit that they will amend it suitably. Lokayukta Act will be amended to that effect.
That
With Section 17A. It is, my lord. If my lord peruses their affidavit, my lord. Page 26, my lord, of their affidavit, my lord. Affidavit filed by respondent 1, 2, 4, and 5. Page 13, paragraph 26, my lord. They themselves are committing to the jurisdiction of PC Act, my lord.
So they say that they will comply 17A.
So they say that they are under the purview of 17A, so they are also under the purview of 19, my lord.
No, not 19 cannot be. They can come under 17A, but not 19, because 19 categorically only refers to a particular act, which does not have any relevance out here.
In that case, my lord, until they amend 17A, their act in tune with 17A, the Lokayukta cannot pass an order of investigation under 19.3, my lord.
Based on a recommendation.
My lord.
See, what is this? Kindly see this. No police officer shall conduct any inquiry or investigation into an offence alleged to have been committed by the public servant under this act, where the alleged offence is relatable to a recommendation. So this recommendation will come only under 19.3.
Now, any recommendation made or decision taken by...
Understood. This recommendation will be made under 19.3 of the Lokayukta Act.
Yes.
Pursuant to this recommendation, they need to follow 17A. That is the how you can read it.
No, my lord, recommendation of the public servant who was work relatable to his...
Relatable to any recommendation made
Or
or
decision-
decision taken by such public servant in discharge of...
When-
Can you see
my
when
lord-
the alleged offence is relatable to any recommendation made or decision taken by such public
So
servant?
that
in
recommendation
discharge of-
have to constitute an offence, my lord.
So this recommendation is for who?
For the accused officer, my lord. If his recommendation or decision amounts to an offence, my lord, alleged offence, then, my lord, prosecution sanction is required.
Now, what do they say in the affidavit?
In their affidavit, they have said that the prosecution sanction stage has not yet come.
Huh?
In respect of me, my lord, petitioner, the prosecution sanction under section 19 stage has not yet come, so I cannot assail that. That is their stand. And in respect of 17A, they say they are contemplating to amend it in tune with PC Act.
Let us see.
Paragraph 26 of their affidavit, my lord.
Who says?
It is an affidavit by the my lord Secretary Gupta Person, Vigilance Department. Respondent, he is filing it on behalf of 1, 2, 4, and 5.
Secretary?
Vigilance,
1, 2, 4,
my lord.
and 5.
On behalf of respondent number 1, 2, 4, and 5,
What do they say?
at paragraph 16 at page 13, my lord. Paragraph 26 at page 13. That with regard to the statements made in paragraph 26 of the writ petition, I said that to avoid the possibility of repugnancy quoted by the petitioner, insertion of 17A of the PC Act in section 19(1), 5, 19(8), and 22 of the Mizoram Lokayukta Act is under active process of amendment and is on the verge of finalization. It is pertinent to state that the instant case has not reached the stage of investigation, and as such, no sanction is required under section 19. So, in respect of section 19, they are, my lord, bit evasive. My lord, they are not.
No, they are not saying about that it will be done as regards 17A.
Is under active process for amendment. Is on the verge of finalization. That means they will suitably amend 19 and 20.
They are not necessary. We don't feel it necessary. They should not. We'll take care of it. Don't worry. Now come to the merits.
But last, my lord, last one document, my lord. My lord, my information, my lord, is that they have made all these selections. They have started functioning after the 2016 amendment, which was never notified, my lord. 2016 amendment, my lord, is date of appointment is not notified, my lord. This is a notification, my lord, I could gather, my lord. 2019, my lord.
Mizoram Lokayukta Act.
2000, if we see, my lord, 14 Act for a moment, my lord.
Huh?
Section 1(3) of 14 Act, my lord. Lokayukta Act, section 1(3), my lord. It says, it shall come into force on such date as the government may by notification in the official gazette appoint.
Wait.
And
Just one.
it is at page 780 of my petition, my lord.
Read your amendment.
Amendment, my lord, starts at page
Enacted.
76.
Shall come into force on such date as the state government may by notification appoint.
this is a notification for only for the 2014 Act under section 1(3) of 14 Act, my lord. So 14 Act was notified in 2019, my lord. Here also, my lord, will see it is given effect from October 2016 when the selection process was initiated. For the amendment, my lord, there is no notification.
Meaning thereby the 2000 2014 Act only came into operation for 1st of October 2016.
16. Reason behind, my lord, and that too, my lord, will see it is notified in 19. This 19
But it
notification.
has been given effect from 1/10/2016.
16, my lord.
But the amending act has not been notified.
Not been notified, my lord. So in that case, my lord, there could not
Yes.
be any selection.
Government.
My lord, I'm not aware whether it was notified or not, the amending act.
Huh?
My lord, I'm not aware on that, my lord. I'll have to see to it, my lord.
How is it possible? Means thereby the entire jurisdiction goes.
Yes, ma'am.
You can't function like this if you have not notified. You'll get it on Monday. Find out. Or 2 o'clock. 2 o'clock. It's very nearby.
May I please interfere?
Huh?
I am special PP for Lokayukta, respondent number 3, my lord. I'm appearing
You are
this.
not from Aizawl?
I am from Delhi.
Oh, you are from Delhi?
Yes.
Okay, fantastic. Tell me.
So, my lord, if you kindly see my affidavit at page number, even in their affidavit also, in their petition, page number 111, 111. Annexure C.
Yes. Tell me.
See, here it was notified on 18 April 2016.
No, this is for general information. Kindly see 1.3. It shall come into
Not
force
that
on such day as the state government by notification in the official gazette point. Then,
My lord,
then Mr. Goswami, you were arguing unnecessarily. This was the point which you should say.
this point has not pleaded in his pleading at all. Otherwise, though, we could have
Even I
taken.
could get hold of this notification recently. my lord.
What are you going to do if he had taken it in the pleadings also? If the act has not come. What can you? Means the entire Lokayukta office has gone for a 6 without that notification.
My lord, the
If
first-
it was pleaded in the pleading, we could have.
What are you going to do? All your actions would have been bad, isn't it? Unless you notify that document.
I can file an affidavit to that effect, bringing it on record, my lord.
Okay, bring it during the day, the course of the day.
During the day, difficult, my client resides in Delhi, my lord.
So what? File it by bringing on file it by yourself. Bring it on record. This thing. We'll take it up at 2. File it. Affidavit.
That will be at 2:30 at least, my lord.
Okay, or we'll take it up on Monday.
Then, my lord,
Whatever you feel like. Today or Monday. Monday. Take it up on Monday. You bring on record that
my
aspect.
lord, I'll try to be remaining Aizawl, my lord. If I don't, my lord, if I fail, I may be allowed to do it virtually, my lord.
Then if I don't hear you, don't take again the example because this I'm going to finish it off. We are not keeping it unnecessary. If you don't have that point, then nothing is there. We will go into the merits. Otherwise, we are not satisfied as regards the other question. If it is not yet been done, not done. Matter ends, finished. And if it has been done, we'll have it on Monday.
Monday, my lord.
You file your affidavit by today. Short. Anybody ask your junior to file an affidavit?
Me being
to
acquainted, I can also file. I am being acquainted with the facts, I can also file.
that you have come to know about this thing, and you file and give a copy to them.
My lord.
Lord, one thing I would like to say, very simple thing. Even Vakalat Nama, I have never seen, he can file along with Vakalat Nama also.
I have instructions to
bet
appear, I
he-
can file that also, my lord.
Mr. Counsel, we don't go into those trivial things.
Yes, that is quite simple.
We go into the question first. Otherwise, this court is satisfied with the validity, the virus of that. But if that particular thing has not yet been done, because he has also, it has only come to light to him now.
Yes, my lord.
He has today only said, because all along, otherwise, why would he challenge and in fact, his repetition is useless. Oh, on that ground, we should dismiss it. There is a Supreme Court judgment. If an act which has not been notified, how can you challenge?
Let whether notified or not, that be decided first, my lord. Then my lord may pass that.
So nothing, if it has not been notified, how can you challenge the act?
I'm deeply obliged.
Okay. Mr. P.N. Goswami, the learned counsel appearing on behalf of the petition, submits that to his information, it was only by the notification dated 17/1/2019 that the Mizoram Lokayukta Act 2014 was notified with effect from 1/10/2016. He submits that there is no other notification by which the
Commencement, my lord, or date of appointment. 2016 amendment, my lord.
by which the Mizoram Lokayukta Amendment Act 2016 was brought into force as is required under section 1(3) of the said amending act. Full stop. The learned counsel submits that he would like to file a short affidavit bringing on record the said aspect during the course of the day. Full stop. Taking into account the above and the matter having been substantially heard, list this matter again on 28/10/2024. Full stop. In the meantime, both the state respondent as well as the respondent appearing on behalf of the Lokayukta Mizoram shall apprise as to whether the Mizoram Lokayukta Amendment Act 2016 have been notified and had come into force in terms with section 1(3) of the amending act of 2016.
Briefly.
Item number 3 and 4.
Are they filing? But this is for the hearing?
Two items are clubbed together, Lordship. The
Which is
PA
this
number.
matter?
Yes, this is item number 3.
Oh, yes, we remember.
Yes, and I
Where there is a mutual agreement between Mr.
Between the
Malhotra
parties,
and
yes.
his client.
and the state has filed our affidavit, Lordship, as per this court order.
Certain whether sufficient vacancies are available. Now, in view of this affidavit, we say that nothing remains in the appeal, and the authorities shall now comply as per the direction passed by the learned trial court, the single judge. Because learned single judge say that to convey that initially there were 4 posts, of which the petitioner was there and there were 4 respondents, private respondents.
Yes, my lord.
And to convene the DPC. Because the learned single judge did not have direct appointment. If you see the judgment of the learned single judge, he made it very clear. And let's see the last portion. Para 13. The state respondents are now directed to convene a fresh departmental promotion area to fill up 4 posts of LDC after condoning the age of the petitioner as well as per the exporter approval directed to be granted. The entire process shall be carried out as expeditiously as possible and preferably within 2 months from the date of receipt of the certified copy. The DPC will be allowed to accommodate the petitioner as well as all respondents if there are sufficient posts, and if not, the principle of so and so is come. So the single judge has directed the consideration. The single judge has not directed appointment.
That is correct, my lord. Besides, my lord, the grievances of the present appellants is that they were, at the time of consideration of the case for regularization, my lord,
Huh?
while they were considered for regularization, the writ petitioner, who is senior to them, was not considered because of the fact that he was overaged during his initial
You are
entry.
also overage now.
No, my lord. We were already regularized, and we were regularized on the year 2020. And only due to the present impugned judgment order, he had acquired right for consideration to overage condonation. So we have already rendered service for more than 3 years. So
More than?
3 years, my lord, on regular service. So now, due to the existing vacancy which arose subsequently, the appellants as well as the writ petitioner, they can all be accommodated to the said post. So my humble prayer is that, my lord, without disturbing, interfering with the regularization already done to the appellants.
Set aside, set aside, para 13.
This may be modified, my lord, this para 13. Because in any event, my lord, the writ petitioner, in the event of her regularization, my lord, due to her age, she will not be getting any further promotion.
Actually, my learned friend is referring to para 12 because the regularization order was set aside.
Now, appeal has been filed by everybody because all the regulation orders have been set aside.
Yes, my lord.
So now you won't get the benefit of seniority. No, seniority too does not arise. He will be senior.
No, my lord. Of course, even he is a senior to us after regularization. He will not be getting any further promotion due to her age.
No. Unless he is regularized, because he was appointed initially in what post?
One post.
Your Worship, initially we were all muster roll employees. As per the scheme made by the government, we were considered for regularization as per the scheme. At the time of consideration, my case was rejected on the ground that at the time of my initial appointment, I was overage. I challenged the decision, and due to the actions taken by the respondents in other cases, the Honorable Single Judge directed that I should be given age relaxation to be considered for regularization. And the regularization of the private respondents was set aside, and there was a direction to consider the cases afresh. A fresh DPC was directed to be constituted.
Now, if there is a fresh DPC,
Yes.
would many other people won't come?
And that is what they're scared
There's a
of now.
chance. There's a chance.
That is what they're scared of.
What is your basis to take it?
Lordship, there are 7% considered for the DPC,
7%.
7%.
And of which you have only 5 posts.
Yes, 4 posts at that point of time.
And now,
Now 5 posts.
so
So
5
7%
posts,
will
and
be
how many
considered
persons
for
are there?
DPC.
7.
The others who were rejected at the time of consideration, they did not approach the court.
However, Lordship,
Only
They will also come into the, once a DPC is held,
yes,
they and many others will come into the
Yes.
zone of consideration.
yes. That is what the appellants are scared of now.
Not under appellants. The appellants, the question is, let us see the facts of the case.
Well, the DPC rejected my case because I was overage at the time of my initial appointment.
You are senior. You 4, 5, 6, and 7. Petitioner is 3.
Yes, my lord.
And what is how do you appoint? Well, what is the criteria? Where is the scheme?
It's in page number 49. Writ appeal number in the writ appeal number 1 of 2024, my lord. Page number 49.
Office
Where?
memorandum. No. Where is the scheme?
This is the scheme, my lord.
Yeah, WA 1 of 2014, Your Worship.
Master roll employees to regular post.
They have
Government
rendered,
of Mizoram regularization of master roll employees scheme 2018. That's it.
yes, my lord. Para 3 and para 4
And para 6.
and para 6. 7 years continuous engagement is required. And the initial appointment has to be done with the approval of the DPNAR and Finance Department. And on the following page, my lord, page 51, the meeting minutes of the DPC is there.
You were not overaged at the time of initial engagement?
He was.
I
he
was in 96. So that is why,
Now, were you overaged at the time of initial engagement?
yes.
Then how can that be taken note?
That is the reason he was
Your-
found
He condoned
ineligible
the
by
year
the
for
DPC.
such, unless such employee was already overaged at the time of initial engagement.
So Your Worship, that is why I challenged the decision, and at page 63, the government had condoned the, if Your Lordship will kindly see page 63.
Has the government condoned so far as these private response number?
Yes, they also condoned, but
No,
since
but
they were not
where you
overage.
There is no question of condemnation in my case. We are eligible as per the scheme.
So then, so you are not entitled to.
Your
You have
Worship,
no case.
I was not entitled, but Your Worship, I challenged the decision, and if I may take Your Worship to page 63, the office memorandum whereby the state respondents had come to a decision where the Basti roll employees were engaged without proper approval of the government, their appointments were condoned. Page 63,
For other departments, not our department.
we are included.
Which department you are?
We are in irrigation department.
Ah.
This is in respect
Whereas
of
the
three work
three
department.
departments so and so have engaged a large number of master in violation of the government demand. Whereas the government in the meantime introduced for regulation of master man and about excluding those without the knowledge. Without the demanding express Where does it say that it is that they are going to dispense with this? Because this is a rule under 309. It's a statutory rule.
Yes,
How
yes.
can a statutory rule be done away with?
No, Your Worship, it's
If you
not.
were not eligible at the time of initial appointment.
Your Worship, we had submitted that since the government had approved the
Right? Mr. Malhotra, even by way of an office memorandum also you cannot divert to this or this mandate which is given in clause 6 in Rule 6 cannot be there, taken care of.
Your Worship, our case was that since the government had condoned the appointment of the muster roll employees in violation of the government instructions from time to time by this office memorandum, and since we also fall under works
Whatever
department.
the government has done,
Yes.
but the court can it say that by whatever the government has done,
Yes.
that's illegal. Absolutely, that is illegal. But can the court say that as the government has done some illegality, we again perpetuate more illegality?
Your Worship, it is not the case of the it is not the case of the respondents that the this office memorandum is in violation of the rules.
Absolutely not necessary.
Yes.
It is your case
Yes.
that they are doing so. Kindly give me also the benefit.
Yes. Similar
We allow
treatment.
this appeal.
We had asked for similar treatment, Your Worship.
We allow this appeal. However, we say that taking into account the petitioner may be, but you can't do that. Be condoned by the government for such unless such employee was already. So unless you challenge clause 6, rule 6.
If Your Lordship will kindly see the order dated 5th of September.
Because by way of an executive instruction, his office memorandums are 161.
But Your
And
Worship,
Article 161.
But-
And if that be so, then under what circumstances it is possible?
Your Worship,
You cannot go beyond that.
the government had condoned the appointment, illegal appointments of all the muster roll employees in all the works departments.
Fantastic. The government can do. The government, you.
That is-
therefore-
that is
therefore,
why, Your
Mr.
Worship-
Malhotra, you approach the government to do.
That is
But
why-
this is not the case which can be done.
But that was a main ground, even in the. if we do-
This cannot be done because the rule is very clear. If you were not, you cannot. The condonation can only happen if you were not overage at the time of initial. Otherwise, you challenge the rule.
The government had given contribution to all the muster roll employees who were
So you
employed
should have
illegally.
been, you should have been in the good books of the government,
That is
not
why,
before the court.
that is why, Your Worship,
Moreover, Lordship, this OM, office memorandum, is basically meant for those 3 works departments.
No, maybe, but can by these office memorandums are documents coming within the ambit of Article 161. They cannot take away or be in violation to the statutory rules under 309. I would have understood if it was an office memorandum. Like in Nagaland, they have come up with an office memorandum. These are not 309, but these are 309 rules.
I understand, Your Worship, but then, I mean, this is, since the illegal appointments of muster roll employees in other work departments was condoned by the state government,
So,
we are
so
seeking parity.
If the government keeps on committing illegalities, so this court should say, okay, the government has done illegalities for A, so why not we should permit for B also? Would this court also not be hand in glove then with the government?
Your Worship, there is nothing to show, Your Worship, that this office memorandum is in violation of the scheme.
Don't put us also into the status of madam.
My humble submission, Your Worship, is this office memorandum condoning the illegal appointments.
You cannot. That office memorandum is absolutely illegal. But why should we go into the question of the office memorandum? Because the office memorandum cannot override Rule 6. Rule 6 is very clear. If you were not, cannot. So under such circumstances, the appointments are okay.
Your Worship, in spite of this, Rule 6, the government in its own wisdom had condoned the illegal muster roll employees.
Understood.
So that is why, Your
So
Worship,
therefore, do you mean that this court should be a party to that illegality? You want now that as government has some illegality, this court also should
Yeah,
say,
I understand,
okay,
yeah.
let the government do further perpetuate illegality.
if we go according to the affidavit, they have not stated that this OM was
They
in.
dispose of the petition appeal now. You take up both the appeals and dispose them now. Urge so and so, the learned counsel appearing on behalf. Urge so and so, the learned counsel appearing on behalf of the appellants in WA number 5/2024. And you are in which one?
The same bill is WA 5.
WA 1 of 2024 and so, the learned, you are additional,
GA.
you are
Government.
GA, the learned so, the government advocate appearing on behalf of in WA number 5 oblique 2020.
If I may take your lordship to the order dated 5th of September.
Huh?
If I may take your lordship to the order dated 5th of September
Of what?
of
This
the
court?
of this honorable court.
Let it be.
It does not have any binding, my lord. This is
Now my learned friend is again.
Not necessary. No, because if we allow it, see, the court has gone into another aspect, mutual agreement. This mutual agreement means, are we not violating? Can I say today, I would have understood you were eligible, you were dropped out. Anyway, Mr. A.R. Malhotra, the learned counsel appearing on behalf of the respondent.
Your lordship, the second last paragraph, your lordship.
One, respondent number 1. Respondent number 6, appearing on behalf of the private respondent. Full stop.
If your lordship will
Both the appeals arise out of the judgment dated 18/5/2023 passed in WPC number 72 oblique 2022 by the learned single judge, whereby the learned single judge had set aside the minutes of the meeting dated 20/11/2019 and the consequential order dated 4/2/2020 regularizing the appellants in WA number 1 oblique 2024 who were the private respondent number 6 to 9 in WPC number 72 oblique 2022. Full stop. The learned single judge further directed that a fresh departmental promotion committee be convened to fill up 4 posts of lower division clerks bracket LDC after condoning the age of the petitioner in WPC number of the petitioner as per the ex post facto approval directed to be granted. It was further directed that the DPC would be at liberty to accommodate the petitioner and all the private respondents in the writ petition if there are sufficient posts, and if not, the principle of last come first go shall be followed. Full stop. For deciding as to whether there is any infirmity in the judgment and order dated 18/5/2023 passed in WPC number 72 oblique 2022, we find it relevant to take note of the certain factual aspects which are narrated infra. Next. The case of the petitioner in WPC number 72 oblique 2022 was that she was initially engaged as a master role (MR) lower division clerk LDC on 10/1/1996 without the approval of the government. She continued to work as such under in the office of the executive engineer Lunglai division, irrigation and water resource department, who was the respondent number 5 in the writ petition, until she was engaged with the approval of the government in the DPA and AR and in the finance department through engagement card dated 23/4/2012. Full stop. The petitioner there was first engaged for the period with effect from 1/3/2012 to 28/2/2013, and thereafter her engagement was extended from time to time and continued till the time of filing of the writ petition. Full stop. It is also relevant to take note of that the state respondents had, by an office memorandum dated 29/5/2018, provisionally fixed the inter se seniority of the master role LDC employees. Full stop. In the said office memorandum, the petitioner was placed at serial number 3, whereas the private respondents number 6, 7, 8, and 9, who are the appellants in the writ appeal number 1/2024, were placed at serial numbers 4, 5, 6, and 7. Full stop. At this stage, it is pertinent to mention that the government of Mizoram had, in exercise of the powers under Article 309 of the Constitution, where is that page?
Page number 49, my lord.
49. In exercise of the powers under Article 309, powers under the proviso to Article 309 of the Constitution, formulated a scheme called the Government of Mizoram Regularization of Master Role Employee Scheme 2018. Full stop. This scheme was made for giving scope for regularization of master role employees to regular posts under the government of Mizoram. It applied to master role employees in Group C and Group D categories under the Department of the Government of Mizoram, who were duly employed by means of engagement cards issued by the competent authority with the prior approval of the Department of Personnel and Administrative Reforms and the Finance Department under the revenue expenditure heads of the accounts of the state, and upon the recommendation of the Departmental Promotion Committee duly constituted by the government in respect of master role employees engaged on or after 19/2/2014. Full stop. It was also mandated that the said scheme was not applicable to master role employees engaged on coterminous basis under the state government centrally sponsored scheme and any other scheme born employees. Full stop. Clause 4 of the said scheme being relevant is reproduced herein under page 49 of Pavdi. Full stop. From a perusal of the said clause 4, it would be seen that the eligibility conditions for regularization were duly mentioned. Full stop. For a person to be entitled eligible to be considered for regularization was that the person must have been continuously engaged as master role engaged in the master role capacity for not less than 7 years. Full stop. In addition to that, the person should possess the educational, in addition to that, the said person should possess, number one, such educational and other qualification prescribed by the relevant recruitment rules for the corresponding post. Roman 2. The performance report of such master role employees prepared by the controlling officer for the preceding 5 years shall not be below the benchmark. Number 3. The regularization shall be made on the basis of, in the order of length of service on master role capacity, as given in the order of fixation of the final inter se seniority issued by the competent authority, subject to clause Roman 2, that is, the performance report of such master role employees. And number 4, such regularization shall be made against 35% of the direct recruitment quota in the corresponding post. Full stop. It is further relevant to take note of clause 6, rule 6 of the said scheme. And the same is reproduced herein below. Page 15. From a perusal of the said rule, it would be seen that the upper age limit of a master role employees may, while being considered for regularization under the scheme, be condoned by the government for such regularization. However, there was a complete bar in exercising the powers under Rule 6 if the employee was already overage at the time of initial engagement. So, circling back to the facts involved, it would be seen that where is the impugnement?
Page 51.
Huh?
Page 51, the impugnement. Page 51.
Back to the facts involved, it would be seen that the Departmental Promotion Committee had taken into consideration the candidature of the petitioner as well as the private respondents. In its meeting held on 2011-2019 against the filling up of 4 posts of LDC in level 4 of pay matrix under the Irrigation and Water Source Department. Full stop. There were 7 candidates who have applied, who were brought within the zone of consideration. However, the persons at serial number 1, 2, and 3 in the as per the inter se seniority were rejected, and the private respondents herein in a writ petition were recommended for regularization. It is relevant to mention that as per the minutes of the meeting, the persons at serial number 1, 2, and 3, which included the petitioner in serial number 3, were rejected on the ground that at the time of their initial engagements, they were overaged. Full stop. Pursuant thereto, an office order was passed on 4th of February 2020, whereby the private respondents, who are the appellants in writ appeal number 1/2024, were regularized to the post of LDC in the level 4 of the pay matrix, bracket 25,500 to 56,800 plus other allowances. Full stop. Being aggrieved, the petitioner after submission of certain approach this court by filing the writ petition, which was registered and numbered as WPC number 72/2022. Full stop. The learned single judge, by the impugned judgment and order, allowed the writ petition, thereby setting aside the minutes of the meeting held on 2011-2019, as well as the office order dated 4/2/2020, and thereby directed the DPC to reconvene and take into consideration the and to make recommendation to fill up the 4 posts of LDCs after condoning the age of the petitioner. Being aggrieved, the present appeal have been filed by the private respondents in WPC number 72/2022, which is writ appeal number 1/2024, and by the state of Mizoram, which is writ appeal number 5/2024. Full stop. We have heard the learned counsels appearing on behalf of the petitioner appellants in writ appeal number 1/2024, as well as appellant number as well as the writ appeal number 5/2024. Full stop. We have also heard the writ petitioner, who is the private respondent in both the writ appeals.
Your Worship, if I may, I know I'm going to cause inconvenience, but if just one submission may kindly be considered. If I may take Your Lordship to the affidavit filed by the state, the age limit for direct recruitment is between 18 to 35 years. When I was appointed in 96, I was 24 years.
You were?
24 years.
Then?
So that means at the time of my initial engagement, I was not overaged.
No. You have to form from the engagement card.
Yes, Your Worship.
Formal engagement.
If Your Lordship, yes. No,
Initial appointment will be taken from an engagement card.
so if Your Lordship will see, I'm sorry, yeah.
You entered, you were given the engagement card on 1/3/2012, na?
Yes.
That is your problem. Because if you see the rules, these schemes shall apply to master roll employees and under the categories who were duly employed by means of engagement cards issued by the competent authority with the prior approval of so and so.
Yes, Your Worship. So, Your Worship,
Now, how many years of service?
Your Worship, in 2012,
Not much.
yeah, no, what I'm trying to say is in 2012, when I was given regular muster roll employment, I was 40 years.
You were?
40 years. And if Your Lordship will go to page 18,
Or?
sorry,
Huh?
the rules have been annexed by the state respondents. The LDC rules.
Where? Which rules? Where? Which affidavit?
Page 82. These are the Mizoram Ministerial Service Rules 2011. And page 84. Rule 10, subclause 2.
Ah.
It's overage by 2 months.
What are you saying?
No, Rule 10, subclause 2, Your Worship. Page 84. Age limit.
Direct recruitment to the assistant so-and-so shall be between 18 years and 35 years, and the upper age limit may be relaxed to 5 years in case of scheduled caste and scheduled tribe. Yes, then?
So, Your Worship, that means I was 40 years in 2012. So, up to 40 years can be relaxed. As
So
per
you
this.
ask for relaxation, we
My
give you
lord.
that liberty.
She was born on 21st January, and she was given a formal engagement in the month of March.
Huh?
In the month of March, she was given formal engagement. That means she was overaged by 2 months at the time of giving formal engagement.
2 months only.
2 months.
We have heard the learned counsels appearing on behalf of the appellants, so and so. Appellant appearing on behalf of the appellants. Number 1, in writ appeal 1/2024 and writ appeal number 5/2024. The submission of the learned counsel appearing on behalf of the appellants is that the learned single judge out in law in taking into consideration that Rule 6 of the of the scheme categorically mandated that the government could condone the age limit only if an employee was not overaged at the time of initial engagement. Full stop. The learned counsel submitted that as this scheme was made in exercise of the powers under the proviso to Article 309 of the Constitution, unless there was any amendment to Rule 6 of the scheme, no executive instruction or office memorandum can go against the scheme, against the mandate of Rule 6. of the scheme. The learned counsels appearing on behalf of the appellants further submitted that the office memorandums to which the learned single judge relied upon were in respect to some other departments which had nothing to do in respect to the irrigation department, irrigation and water resource department. It was further submitted that the learned single judge failed to take into account take note of the well settled principles that there cannot be a negative equality inasmuch as the same would perpetuate illegalities. Per contra, Mr. A.R. Malhotra, the learned counsel appearing on behalf of the private respondent who was the petitioner, submitted that the various office memorandums which have been issued by the Department of Personnel Affairs of the Government of Mizoram would show that the state government have condoned the age limit. And as such, the petitioner also is entitled to entitled to be considered for regularization upon condonation of her age limit. Full stop. He therefore submitted that the learned single judge had taken into account the principles of equality enshrined in the Constitution, have set aside the impugned minutes of the meeting, as well as the impugned order, minutes of the meeting, date to deliver, and the order, and directed a fresh DPC to take into consideration the filling up of, take into consideration the filling up of 4 vacant posts. He further submitted that as of now, there is another post which have become vacant, as would be seen from the latest affidavit filed by the government. And as such, the petitioner can very well be accommodated.
Your Worship, just one, and the petitioner, as on in 2012, when she was appointed as per the rules with government approval, she was running 40 years. She had not completed 40 years. So, as per Rule 10, Subclause 2 of the Ministerial Service Rules 2011, her case may be considered because she had not completed 40 years. According to Rule 10, Subclause 2, it is 35 years, relaxable by another 5 years for STs. So she was running 40 years. She had not completed 40 years. So that may be considered by the department.
He further submitted that in terms of it, where is that rule?
Page 82, Your Worship. It starts on page 82.
He further submitted that in terms of it, Rule 10.2
Yes.
of the Mizoram Ministerial Service Rules 2011, the age limit can be condoned, can be relaxed. Then the age limit is to be relaxed by 5 years in respect to scheduled caste and scheduled tribes. And as such, the petitioner who was 40 years,
Running
40 years,
40 years, running 40 years.
who was 40 years,
Yes.
who was nearing 40 years,
Who was 40 years?
who was 40 years as on the date of the petitioner's initial engagement,
On 23/4/2012.
ought to have been, can be very much taken into consideration, ought to have been taken into consideration by applying the said rule.
Somebody cannot pay. Somebody cannot 41 color 40
We give it to come back.
Okay.
We are not going to touch their appointments.
Yes.
Let me just think about how to give you something
Yes.
by applying 10 to something. And that post which is vacant now,
Yes.
where you can be considered.
Consider.
If that can be done, it is okay, but without touching.
Yes.
What was your age as on that date?
On 1st of March 2012, when I was engaged on masteral basis with government approval, I was 40 years and about 2 months.
Huh?
40 years and 2 months.
Then how do you come?
I've not completed 40 years.
40 years and 2 months?
Well, I was running 40.
No.
I was born on 21st. Your Worship, it does not say that it should exceed 40 years. I was relaxed up to 40 years, up to 5 years. So, Your Worship, I was running 40 years. I had not completed 40 years. Your Worship, now if I'm 39 plus 11 years, that means I'll be 39. I won't be 40. So I'm 40 years plus 2 months. So I won't be 41.
We have heard the learned counsels appearing on behalf of the parties and have given our anxious consideration. First, in the foregoing paragraphs of the instant judgment, we have duly taken note of the scheme pertaining to the regularization of master role employees. Rule 6 of the said scheme makes it very apparently clear that the government has been given this power to condone the upper age limit of the master role employees. However, in doing so, the government cannot condone the age limit in respect of an employee who was already overage at the time of initial engagement. Stop. A perusal of the minutes of the meeting dated 2011-2019 What is the date of initial engagement?
1996. And engagement as per the approval of the government is 2012. The writ petitioner.
Then kindly come to page 52 of the memo VP. This is 7 years minus, na? We have to minus 7 years from here because this was held in 2019. Would show that the respondent numbers 5, 4, 5, 6, and 7 in the writ petition, who are the appellants in writ appeal number 5/1/2024, where and would show that the 7% would show that the 7 persons who were within the zone of consideration were initially engaged, were all initially engaged on 1/3/2012. First, in respect to the appellants in writ appeal number 1/2024, who were at serial number 4, 5, 6, and 7, their initial date of engagement, their age at their initial date of engagement, that is 1/3/2012, were 35 years or below. Full stop. On the other hand, the master role worker employees who were at serial number 1, 2, and 3 as per their initial age of, as per their initial date of engagement, were 40 or above. We have also taken note of that the scheme for regularization of the master role workers were made in exercise of the proviso to Article 309 of the Constitution. And as such, it would come within the ambit of a statutory rule. Therefore, when Rule 6 categorically mandated that the government had the power to consider condoning the age limit, but cannot condone if the candidates were overage as on the date of their initial engagement. Unless and until there is an amendment to the scheme, no executive instruction in the form of an office memorandum can permit the government to condone the delay, condone the age limit, if the person, the candidate, was overaged as on the date of their initial engagement. In view of the same being a proposition of law, well-settled proposition of law, we are of the opinion that the learned single judge had committed an error in applying the office memorandums in spite of the clear stipulations contained in Rule 6 of the scheme, and thereby interfering with the minutes of the meeting dated 20/11/2019, as well as the office order dated 4/2/2020, According, in that view of the matter, we interfere with the impugn judgment and order dated 18/5/2023, passed in WPC number 72/2022. Full. Accordingly, both the writ appeal stands allowed. Before parting with the record, do we find it, however, apposite to mention, observe and mention that observe and take into observe, we find it apposite to observe, taking into consideration the submission made by Mr. A.R. Malhotra, the learned counsel appearing on behalf of the writ petitioner in WPC number 72/2022, whereby he submits that in terms with the Mizoram, where's the rule?
Page 82, yeah.
Is in terms with the Mizoram Ministerial Service Rules 2011, and more particularly Rule 10(2), the upper age limit in the case of direct recruit to assistant grade, UDC grade and LDC grade may be relaxed by 5 years in the case of scheduled caste or scheduled tribes. And therefore, taking into account that the age limit is from 18 years to 35 years, the learned counsel therefore submitted that the petitioner in WPC number so and so would have been 40 years, as would be seen even from the impugned minutes of the meeting. And as such, the petitioner's age limit could have been condoned. We are of the opinion that could have been relaxed. We are of the opinion that the question of relaxation of the age limit is within the discretion of the government authorities.
Rule 16, yeah. Rule 16.
Huh?
Rule 16.
6.
1/6. Rule 16. Page 86. Interpretation.
1/6.
1/6. Interpretation.
Government shall decide the same.
Yes.
No. So, we are of the opinion that the question of relaxation in terms with section Rule 10(2) of the Mizoram Ministerial Service Rules 2011 is within the discretion of the government. Also, under such circumstances, we grant the liberty to the petitioner to file appropriate representation before whom?
Respondents 2 and 3. Respondents 2 and 3.
Before the respondent number
2 and 3.
before the we put it here before the secretary, before the respondent number 2 and 3 in writ appeal number 1/2024,
Sorry.
seeking relaxation of the age in terms with Rule 10.2 of the Ministerial Rules in 2011. And in the circumstance such relaxation is granted, the petitioner be considered for regularization in terms with the scheme to naam to likhi. Full stop. The said exercise be completed subject to submission of the representation before the respondent number 2 and 3 as noted above within a period of 4 months from the date of such representation, along with a certified copy of this judgment is submitted before the authorities concerned. With the above, the instant both the writ appeals stands allowed.
Item number 5.
In the facts of the case, we are not inclined to impose any costs. Yes, councillors, you have a list of amicus here for jail appeals.
Registry will have it, my lord. The list of legal aid counsel, my lord.
Legal aid counsel. Yes.
Please, Your Lordship. This is
Is
daily
it for
appeal.
hearing? Hearing?
Yes, my lord.
We'll take up the others for which I have actually come. Huh?
All right. In this case, my lord, it may be taken up next week or
We can take it next week, but first and foremost is that this is
302.
302. We have it when? Next week. Today I'll take up those other series matters. No?
After 2 weeks, my lord, that will be.
At the request of the council appearing on behalf of the amicus.
I might ask.
At the request of the councils for the parties, the matters can be adjourned to be listed again on 13th of November.
Yes, my lord. Deeply obliged.
Item number 11 to 21.
Hello, oh. Lordship,
Yes.
this is a case for which a Lordships have come. We know it very well. But the thing is that, Your Lordship, we have received a memorandum of appeal just yesterday, and I don't know whether
You
it will be in the interest of justice if the matter is
Mr.
taken up
Counsel-
next
Mr.
week.
Counsel, let me make it very clear to you. You have a copy of the judgment.
Right.
You already have a copy of the judgment. You have all other pleadings of the writ petition. We are only here to see as to whether the learned single judge was right or wrong. That's all. Now, therefore, the question is, we are therefore to see that, nothing more than that. So all these other materials are already available. Let us not go into other grounds. You see, the state cannot say anything more than what they have already stated. Now, the learned single judge have decided 2 points, primarily, 3 points. The first is as regards the notification of 1965. The learned single judge said that, look here, the state had, the writ petitioners have challenged only this in the year 2000. When did you file the writ petitions?
2017.
Say that they have filed at this stage and they have raised the issue that section 14, 15, 16 and 21 have not been properly complied
Right,
with.
right.
And as such, held that the 65 is bad. The state stand is that we have duly complied with. And as such, this was done in the year 1965. We may have no such, we don't have those documents to substantiate it, but we have duly complied with. Now, on the basis of non-compliance, the learned signatures have set aside the 65 judgment. Number two, the learned single judge held that the state may pay the compensation. In fact, I thought that why the petitioners who were there, in fact, they did not file a cross appeal or anything, because the word may should not have been used. Now, a discretion is being given to the government to pay or not to pay, giving the word direction of may. And this has been done on the basis of...
No, Lordship, that last observation is even during the pendency of the execution cases, which were supposed to be filed, then it is up to the state government, in spite of such execution cases pending, to pay compensation. It does not say that it may or may not pay.
No, in fact, if you are entitled to, you have to get. The question of may does not come. If you see the learned single judge's judgment, the last portion, kindly see paragraph 48. The petitioners B, 48B, of all the above petitioners shall seek alternative remedy for execution of their awards in accordance with the procedure prescribed in the land acquisition case.
Yes, Your Lordship. It's however made clear that despite having directed as above, the state government is at liberty to pay compensation amounts
Given
due to
the
the writ
liberty.
petitioners.
That is why.
Yes.
You see, there are certain cases, it is very difficult to understand, appreciate, as to how you were going to go for execution. Execution comes when there is a reference. The reference, without a reference, there is no decree.
True.
And without a decree, you can't go for execution. So where is your alternative remedy? If it is a violation under Article non-payment, if you see the recent judgment of the Supreme Court in Kolkata Municipal Corporation, it says Article 300A has 7 sub-rights.
True.
Of 1, 2 is one of those sub-rights is restitution, and restitution by making payment of amount compensation. And there is also a direction that this requires an early conclusion. It cannot be delayed. So if it is a violation of any of the 7 sub-rights, it is a violation under 300A. And consequently, this court or any court under Article 2 to 6 can very well take note of the deed. Now, Mr. Counsel, tell me how you are going to go to the civil court for execution of those awards which have been passed by the Deputy Commissioner.
In fact, Your Lordship, in our case, there is a reference case. After reference was decided, we are given the solicium in interest plus the amount of compensation which was awarded by the district collector. So it's a reference case. It's a decree.
In all the cases.
Not all the cases.
That is only one case.
6
Only
of
in
2000.
one case there was a reference.
Yes, there's a reference.
And against that you can. But what about the others? How will they go? They can't go today. Section 18 is not that thing. Section 18, the scope of Section 18 is very limited. You can challenge the determination, the quantum.
Right.
You can challenge the apportionment. You can challenge the area. That's all. This section 18 has to be filed within a period of 6 months from the date of the award, and if you have participated within 6 weeks. Thereupon, they will go under 19, he will make a reference, and 20, the authority will decide, the court will decide. This is the scope. Now, if there is no reference, in one case where there is a reference, one can go for execution. But where is your any other alternative remedy? Tell me. You have no other alternative remedy? You can't go before the civil court because the civil court here is barred. Under the Land Acquisition Act 1894, even under the 2013 Act, it is barred. So you can't go there. Where will you go? Only thing is 226.
That's true.
So why there was no challenge in respect to this B?
Your Lordship, this is a decision of the Honorable Court in respect of all the cases put together by common judgment. And I think in all those 10 writ petitions, reference was not filed in some of the cases. Reference was filed at least in 2 cases.
So
But-
in 2 cases where there is an award, you can go for execution.
Right.
You can go ahead. There's no quarrel with, there's no problem with that. But what about the others? You can't? No.
Lordship, those matters can be addressed by the councils who are appearing in respect of those cases.
Your cases, the reference was there.
Reference is there.
So then you can very well go under 48B.
Right.
That is okay. Now, you have also challenged the 65 notification.
Yes. It is, in fact, in those 2 cases only that 65 notification has been challenged.
So you have challenged the 65.
Yes.
When did you get your rights over the land?
Your Lordship, we have been allotted the land way back in the year 1950 and even prior to that. But the land rights have been given by the village council concerned. And we had cultivated our respective lands. We have depended on the produce of those lands for our livelihood. And thereafter, in the year 1993-94, LSC was issued to those landowners. 1993-94.
Now, tell me, how can there be an LSC issue? LSC is issued under what provision? The 56 Act?
Yes, yes.
Now, 56 Act,
It-
LSC
it-
is
it-
in the 56 Act, if I'm not
No,
wrong.
not 56 Act. It will be under the Agriculture Land Act. Agriculture Land. 56 Acts will be for the purpose of giving allotment in respect of house site and even for other purposes. But there's a separate provision
Yes. Under what provision?
under the Mizo District Agriculture Lands Act.
Where is the Mizoram?
Mizo District, Your Lordship,
Mizo District Agricultural Land. This is the 63 Act.
63.
Now, if it is so, This is parameter, the same provision is here also, which is there in the 56. Section 3 says, this act shall only apply in respect of other lands other than state forest reserves, the soil of all government and public road, all lands in the station reserves of Aizawl, so and so, so and so, so and so. So under such circumstances, if it is a reserve forest, how can there be an LSC issued? LSC will be issued under this provision, but if it is a LSC, if it is a reserve forest, how can there be an LSC issued?
Your Lordship, that's the core issue which is to be addressed here in these writ petitions. If the constitution of that reserve forest under the Forest Act of 1955 is not as per the provision of law, whether it was constituted some 10 years back or 5 years back, it does not mean that the so-called reserve forest has become a reserve forest.
No, but Mr. Counsel, a reserve forest, it was a reserve forest for all purposes and purposes till the judgment was passed by the learned single judge. It may have been illegally notified. It's a different thing. But it was all along a reserve forest till the judgment was passed by the learned single judge. Because the notification was standing, it's a 65 notification.
That's true, that's true.
So if that was a reserve forest, now if you see this definition of this reserve forest and taking into account the Forest Act also, which you also have, a reserve forest, it goes back to paragraph 3.2 of the 6th schedule. And so paragraph 3.2 refers to a reserve forest to be a reserve forest in terms with the Assam Forest Regulation of 1891. So unless why there was no challenge to this notification of 1965 till
2017.
Why?
Because
Why
it was never,
This
it
is a
was,
very important aspect. There is a
Yes.
question of delay.
it was never called into operation. It was never called into operation.
No, it was operational. The moment it was notified, it was in operation.
No,
But
in the
it
fact
was
that-
not for the authorities did not care to give effect to the reserve forest. It's a different aspect to the matter. The authorities thought, okay, land is there. Well, nobody is going to come here. But
That-
why there was such a delay? Because I tell you why. The problem which this court is facing in appreciating the judgment of the learned single judge in this aspect. This was a 65 notification which was preceded by another notification of 1956.
Earlier 56, then 65.
56.
Yes.
Now from 56, then came the 65. The learned single judge said that why there was a delay. In fact, if you see the Assam Forest Regulation also of 1891, there is also no time limit given, during which these claims and counterclaims, all these things will be looked into. While sitting out there in the principal seat, I find many of the notifications, the proposed notifications were there in 1989. In 2011, they are making the final notification. And the prime example you will find is this particular in Kaziranga. That is what the National Green Tribunal was also taking up. The proposed notification under Section 6, which is the preliminary notification under the Assam Forest Regulation, was issued then in around 1972. And now in 2011, after the Green Tribunal caught hold of this government, they came up with the final. So that cannot be a reason for nullifying the notification of 65. Now the delay in filing the writ petition after such a long, maybe they may have lost those papers. So can that, for that reason, when it is a statutory notification issued in the official gazette in the year 1965, which have held the field all this while, can it be nullified on the ground that that document was not produced because of the fact that they say that we don't have it at present because this was done by the state of Assam long time back when we were inside we were just an union territory. So the delay in challenging the notification of the 6th of 1965 seems to be very fatal.
Because there was no occasion for challenging the said
The
notification.
question is, when you are taking an LSE, you want to create a right. Your right which was there, because once it becomes a notification, it comes within the reserve forest, your various rights, legally speaking, is being taken away. It is a different thing that the government was sleeping all the while. The government did not recognize that they had a right. But your right, you did not challenge at that point of time.
Lordship, if the matter needs to be fully and finally heard, Lordship, I think let the state first argue the matter as to why they have filed a writ appeal, and then we'll have a time for reply.
Didn't get you?
Let the learned AG, who is ready to address the Honorable Court today in connection with the various writ appeals, let him address.
Who? The government?
Yes, Your
The
Lordship.
government, I will ask him. Don't worry. I'm putting you the question of 1960. I'm not on the question of the award. Award will look into it because the award were only specific to certain crops, not on the basis of the land. The quantum of compensation which was given, if I'm not wrong, were only in respect to the crops, the standing crops.
Yes, in a number
Not
of
in respect to the
in a
land.
number of awards, it is in respect of the crops.
Not in respect to the land.
In respect of the two writ petitions, 14 and 51 of 2017, 45 and 51, it is in respect of the land, rupees 2 per square feet. In respect of the other awards, it is, as I can understand, in respect of the crops which have been damaged.
Only in two writ petitions it was land. Your,
Yes, yes.
your writ petitions were land.
Yes.
And these were awards. And those awards you have put for reference.
Yes.
And I didn't understand why the solatium was only asked as 6% and the interest was asked as 6%.
No.
Because 6% interest would be in terms with the prior to 84. After 84, the interest which is there is 12% if there is a delay in passing of the award, and 9 and 15
Yes.
as per 34.
Right.
It is 9 and 15. But it is not understood why 6% was sought. Yes, 6% was there. This was prior to the amendment of the Land Acquisition Act of 1894 in the year 1984.
It could be
Prior to
because of
84, it was
misreading.
6%.
Because of misreading, I believe.
Okay, let us hear the state now.
Lots.
But you think about this. Well,
Yes,
I'll ask you to address it. You have to address me on that.
Your Lordship.
Yes, the Advocate General.
My lords, my lords.
Thank God we got a good internet
Yeah.
connection.
Yes, my lord. This is a separate connection,
Fantastic.
the geo connection. That's much better.
Yes,
Lordship, may I proceed?
yes, yes, please.
My lord, the fact remains that the land in question, which was acquired for the Tirial Hydel project, was basically a forest land. It was a forest land. And that is why, my lord, NEPCO paid 24.46 crores as afforestation, compulsory afforestation. And permission was sought from the central government under Section 2 of the Forest Conservancy Act. Now, my lords, the occupants or the residents of that particular area, my lord, were basically encroachers, unauthorized occupants. The reason is, my lord, the state or the central government did not give them any sanction under Section 2 of the Forest Conservancy Act
That came only
for
in
the purpose
1980.
my lord, their rights or title or ownership, nothing was given. No sanction was given, my lord. And that is why, my lord, they did not accrue any right. Issuing land settlement certificate, that is LSC or pattas, my lord, that was not at all legal. And that is why the Chief Secretary on 5th of August 2016 had to take a conscious call and cancel all the LSC certificates. Now, my lord, I will place reliance on 2009 5 SCC page 373. My lords can. I'll come to the relevant paragraph. But before that, I would like to draw your lordship's kind attention to the head note, my lord. The requirement to obtain. Shall I carry on?
Yes, yes.
Requirement to obtain prior approval of central government before passing order as to de-reservation of forests or use of forest land for non-forest purpose and applicability. Whether Section 2, retrospective in operation, that is applicable for any action which state government could take with reference to activity undertaken in any reserve forest or forest land prior to date of the enforcement of the 1980 Act. Considering the object of 1980 Act and legal principles laid down by the Supreme Court, reiterated, after enforcement of 1980 Act, state governments cannot deal with reserve forest or forest land and permit use thereof for non-forest purposes, except after obtaining prior approval of the central government. Further, even if any forest land or any portion thereof have been used for non-forest purpose for a particular length of time prior to enforcement of 1980 Act, the tenure of such activity cannot be extended by way of renewal of lease or otherwise after enforcement of 1980 Act without obtaining prior approval of central government. If I can take your lordships to the operative portion of this particular judgment in paragraph 52, page 399. Paragraph 52, page 399, members. Para 52, my lords. In the result, shall I proceed?
Yes.
In the result, the appeal is disposed of in the following terms. The policy decision taken by the government of Kerala to assign 28,588.159 hectare acres of forest land to unauthorized occupants, encroachers, after seeking approval from the central government does not suffer from any legal infirmity, and the High Court rightly declined to interfere with the said decision. So it was a policy decision of the government, my lord, to regularize and assign that particular forest land to the encroachers under section 2, taking the recourse to section 2 of the Forest Regulation of the Forest Conservation Act and taking permission from the central government. After the enforcement of the 1980 Act, neither the state government nor any authority can make an order or issue directions for de-reservation of reserved forest or any portion thereof, or permit use of any forest land or any portion thereof for any non-forest purpose, or assign any forest land or any portion thereof by way of lease or otherwise to any private person or to any authority, corporation, agency, or organization not owned, managed, or controlled by the government except after obtaining prior approval of the central government. Conclusion D recorded by the High Court in para 103 of the impugn judgment is legally unsustainable and is satisfied. As and when the state government decides to assign 10,000 hectare acre of forest land to unauthorized occupant encroachers, it shall do so only after obtaining prior approval of the central government, and the latter shall take appropriate decision keeping in view the object of 1980 Act and the guidelines framed for regularization of encroachments on forest land. So, my lords, thereafter, I would
Mr. Advocate General, why don't you come to paragraph 51?
yes, my lords.
51 down below, after putting the affidavit of the Kerala government.
In view of the stand taken by the state
Yeah.
government,
Yes.
the grievance made by the appellant in that regard will have to be treated as premature. However, we deem it necessary to clarify that as and when the state government takes a decision to assign 10,000 hectare area of forest land to permit use thereof for any non-forest purpose and approaches the central government for grant of approval in terms of section 2, 2 and 3, the latter shall be duty bound to examine the proposal keeping in view the object of 1980 Act. Yes, my lord. The state government here did not approach, my humble submission, my lord, did not approach the central government to regularize the occupants or the encroachers with regard to that particular land encroach under section 2. Had it been so, then this principle would have applied. Then paragraph 52,
Forest conservation.
clause 1 and 2 would have applied.
Indian forest. Conservation. This is the
Section 2, my lords,
Forest Conservation Act 1980.
1980. Section 2.
বদলাই
My lords have got it.
They have recently amended, na?
2023.
This is the 27 Act. 27 Act is here.
Forest Act. The Indian Forest Act 27.
Done. If the Indian Forest Act is amended or done.
No, I am on the Forest Conservation Act 1980, my lords.
Conservation Amendment Act.
My lords will kindly come to section 2. Which is in fact a non-obstante clause. It overrides all other laws.
Can we have an old one? Older version of this.
Change code.
Was the Forest Conservation Act made applicable to the state of Mizoram?
Yes, my lords.
It was adopted?
Yes, my lords.
When?
And I'm unable to say the exact date,
Because
but
as per
it
the
was
schedule-
adopted, and the land in question, the land in question, my lords, the clearance was taken for the land in question, which was acquired under section 2.
old prior to this 2022 Forest Act, Forest Conservation. Old book, some old. Huh? Check it out in the library, some old book. Huh? Because this is new. There have been amendments. Now, a reserve forest, Mr. Advocate General, was outside the scope of the district councils. Was it? Kindly come to paragraph 3 of the 6th schedule.
Paragraph. Powers of the district councils and regional councils to make laws.
The regional council for any autonomous region in respect of all areas within such region, and the district council for any autonomous district in respect of all areas within the district, except those which are under the authority of the regional councils, if any, within the district shall have the power to make laws with respect to. Kindly come to B.
The management of any forest
A,
not being a reserve.
the allotment, occupation, or use or setting a part of land other than any land which is in reserved forest for the purpose of agriculture or grazing, or residential or non-agricultural purpose, or for any other purpose likely to promote the interest of the inhabitants of any village or town. So here reserve forest is out. Then provided that nothing in itself prevent the compulsory acquisition of land whether occupied here. Then kindly come to B, the management of any forest not being a reserve forest.
Reserve forest.
Then you see, kindly see 2. In this paragraph, reserve forest means any area which is a reserve forest under the Assam Forest Regulation 1891 or under any other law for the time being in force in area in question. So this will come,
Well,
the Mizo Act will come into the play. Here. Now, therefore, you kindly come 12B, paragraph 12B,
Well,
B.
yes, ma'am. Application of acts of parliament and of legislature of the state of Mizoram to autonomous district and autonomous regions in the state of Mizoram. Notwithstanding anything in this constitution, no act of the legislature of the state of Mizoram in respect of any of the matters specified in paragraph 3 of this schedule as matters with respect to which a district council or a regional council may make laws, and no act of the legislature of the state of Mizoram prohibiting or restricting the consumption of any non-distilled alcohol liquor shall apply to any autonomous district or autonomous region in that state, unless in either case the district council for such district or having jurisdiction over such region by public notification so directs, and the district council is giving such directions with respect to any act may direct that the act shall, in its application to such district or region or any part thereof, have effect subject to such exceptions or modifications as it thinks fit. The governor may by public notification direct that any act of the legislature of the state of Mizoram to which the provisions of clause A of this subparagraph do not apply shall not apply to an autonomous district or an autonomous region in that state, or shall apply to such district or region or any part thereof, subject to such exceptions or modifications as he may specify in the notification. The President may, with respect to any act of the Parliament, by notification, direct that it shall not apply to an autonomous district or an autonomous region in the state of Mizoram, or shall apply to such district or region or any part thereof, subject to such exception or modification as he may specify in the notification, and any such directions may be given so as to have retrospective effect.
So, as reserve forest is outside, the Forest Conservation Act will automatically apply.
My lords,
Would it?
lordship,
Because it is outside paragraph 3.
my lords.
So it would automatically apply. Now, this is okay if it is a reserve forest.
My lord,
But the
my lord,
most
thereafter.
pertinent question is whether it is a reserve forest.
My lords,
The most
Whether it is a
pertinent
forest.
question is whether it was a reserve forest.
whether it is a reserve.
Because the petitioner's case is there is no reserve forest.
Lordship, now the 1965 notification being set aside by the learned single judge. Now, my lord, if I lordship, if I can take your lordship to paragraph, if I can take your lordship to paragraph 40 to 42 of the judgment. 40 to 42 of the judgment, and thereafter I'll come to the other issues and the case laws and why the Chief Secretary had to take a call to cancel the LSCs. My lords will kindly come to paragraph 40. That is page 34 of the judgment.
Where can we get that notification in the memo of appeal?
Which notification, my lords?
Where is the notification?
1965.
65?
1965 is there in my additional letter.
You file an additional affidavit.
Yes, my lords. It is in annexure 6, my lords. Paragraph 19, page 15, annexure 6. My lords will kindly come to page 112 of my additional affidavit.
Wait. This notification was not there before the learned single judge.
I do not find it, my lord. And moreover, my lords, other than the factual aspects, I'm sorry.
This is the notification, 8th of April. Oh no.
No, 19th of May, 1965.
Page
Page 112, annexure 6.
112. This is of 19th of May. Yes, it is actually published on 19th of May, but it is of 8th of April 1965.
That aspect also I will come, my lords. That aspect has also been dealt in this additional affidavits, my lords. I'll come to that.
Yes.
20th of January is also announced.
This is for Khasils.
No, my lords.
Your Worship, it's in the next page, 113.
Next page,
113.
113.
Bottom of the page, 20th January
Oh, in
1965.
exercise. Yes, this is of 20th of January.
1965.
Mizo Act, the Mizo District Council is hereby to
It's a
constitute
continuation.
the following areas at the disposal of the Mizo as the council reserve forest with effect from the date of notification issued on 16th of April 1956 and 16th of September 1967. Forest within
Thereafter, my
half a
lords, will come to
mile
the
on
next
either
page.
side. Within half a mile on either side of the following roads, excluding
Falling rivers.
within 100 meters or 30 meters. Okay.
So this is exactly where the state is agreed, my lord.
So in the Aizawl
This
Silchar
part of the notification.
Aizawl Silchar Road was outside.
Aizawl Shilchar Road was outside. Yes, ma'am. It's half the notification. If my lords come to page 114,
Yes.
this is exactly the notification for which the state is agreed. Setting aside of this particular part of the notification, my lord, because 9,000 square kilometers of forest area will go away. Just to accommodate few people who do not have any rights. Half of the population of Mizoram will lose their rights.
Mr. Advocate General, I think you and me are both in the same position. Kindly read what is there in page 116, 116.
I'm coming to that. My lords, I'll explain that. I have dealt with this aspect in another paragraph.
But it should have been
I will
in
come
the
to that, my lord.
language which the court would have understood.
That was not there before the court, my lords.
It is
My
for
lord,
this
it
court
was
also
not
to
there before the
understand.
learned single judge.
This is for this court. Oh, here it is there. Okay, council are unhappy with the action taken by the president. The president refused to sign his name in the order of union. He decided on the signing the land. Due to reasons, we no longer accept him as the president. Circle of the Act. Okay.
If
So-
my lords allow me,
Tell me.
my lords will kindly come to para 15 of my additional, page 15, I'm sorry, page 15, para 19 of my additional affidavit. Page 15, the question which has been raised by your lordship just now. I've explained this and I'm coming to this. The appellant submits that the Honorable High Court, the Honorable Guwahati High Court, single bench, while delivering the judgment and order dated 27th of January 2021, has committed a gross legal error while quashing the notification published in the Assam Gazette dated 19/5/1965 on the ground that the preliminary notification of riverine reserve forest is dated 16 April 1956, whereas it was published in Zoram, Shiatina, in the issue dated 29 February 1956, which is prior to the date of notification. This was the only ground taken by the learned single judge to quash that particular notification, my lord. However, it is pertinent to mention here that the reason of this discrepancy has not been discussed and logically decided in the judgment and order dated 27 January 2021, passed by the learned single judge, Guwahati High Court, Aizawl Bench. A copy of the Assam Gazette dated so and so is annexed here with Annexure 6. A copy of the notification dated 16th of April 1956 is annexed here with and marked as Annexure 7. True copies of, this is the relevant portion, my lords. True copies of the Zoram Yatina of the issue dated 15 January 1956, 31st January 1956, 15 February 1956, and 15th March 1956 are enclosed herewith and collectively marked as Annexure 8, page 116. I'll clarify this, my lords. If your lordship kindly come to page 116, Annexure 8. My lords will kindly come. That what was the prevailing system going on to publish these types of notification in the official bulletin. This is the system, my lord. My lord will kindly see page 116, left hand side top. The date at the left hand side at the top. January 15, 1956. This is the date of issue. And the executive order is 1st of February 1956, which is translated. The translated version is in page 117.
Why was it published earlier? Means the date on the top is different?
Yes, my lord.
Is an
The
earlier
pub-
date?
Yes, yes. That is this. My lords, I can't give a specific explanation to that. But going through the documents, each and every document, what I can realize is that this was the system which was prevalent during that particular time. My lords will kindly see page 118, same thing, January 31st, and the notification was 18th February 1956. Annexure 6, 118 page. Left hand side top, 31st January 1956, and then the notification 18th February 1956. The translated version is in page 119, 18th February 1956. My lords will thereafter come to the next page, page 120, 15th February 1956, left hand top. Chiatina. And the publicity notes, my lords will see, 24th March 1956. The translated version is in page 121.
It is something like a law journals, some law journals we find which have not, doesn't have much publicity. Like 2020, that day I saw a law journal. I won't name the law journal out here in Guwahati. So
That's it.
they were publishing of 2023 GLJ and judgments of 2024 are there.
It's more or less the same system. My lord. We have got this from the state archive.
Huh?
In fact, my learned junior who is assisting me, she has helped me a lot in this. She got this from the state archive,
Okay.
and that is how we came to know.
Yes.
My lord. Lordship. So this was the system which was going on. And that is why I would most respectfully submit, my lord, that the learned single judge should have considered these aspects before coming to the conclusion that section 14, 15, 16, 18 was not followed, and therefore this particular notification was set aside. Now, my lord, the effect of setting aside this particular notification is huge. It has got a cascading effect in the entire state of Mizoram, my lord. Lordship will kindly come to page 16 of my additional affidavit. Paragraph 20. My lords will kindly see the chart. Page 17 is the relevant paragraph, my lord. It is most respectfully submitted on behalf of the appellants that compliance of the judgment and order of the Honorable Guwahati High Court Aizawl Bench dated 27th January 2021 will involve reduction in the area of the notified forest by approximately 1950 square kilometer, which is quite significant, and such there is every likelihood of environmental damage, ecological imbalance, illegal felling of forest trees, illegal sand mining, etc. My lords will appreciate one particular point, my lord, that this particular aspect of
But why did the Supreme Court, in its order dated 18/9/2024,
my lord,
state about various projects are being held?
No.
Various road
Lordship-
infrastructures are being held. Why?
Lordship, this is another aspect. This pertains to the national highway, which is being proposed to be constructed. This is a matter of MORTH, Ministry of Road and Surface Transport. So this is a national highway which will be constructed from Sairang to Silchar.
From?
So this proposal is being under consideration by the government of India. But due to some of the issues which are related to this particular aspect of land acquisition, these projects were temporarily held up. But I am told now that it is under process of the clearance. I am being informed yesterday.
So this,
Although not yet
So
officially informed,
this
but
notification.
I was told that it is under process.
So this notification has nothing to do.
My lords,
This notification, therefore,
this notification has got a wide scale ramification in the ecology of the state, in the environment of the state.
Now,
The
for
state is
that I
going to do-
understand. We understand that aspect of the matter, but we wanted to know why the Supreme Court was mentioning about infrastructure projects.
Infrastructure
respect to
project
this
of
notice.
NHIDCL, my lords. That is pending. That is pending. Because simultaneously we want that also. If the development has to be brought in the state, we have to construct the roads also.
But now how this notification is becoming an impediment, or the judgment is an impediment towards in respect to infrastructure? That is what I am asking. Is it a question that you may now, once it is being set aside, then you go for compulsory afforestation, then give it to the
Compulsory
government,
CA and
then
NTP.
there is no payment of compensation to the people? Is it something like that?
No, my lords. Not.
No, then
Not
why
like
the Supreme Court mentioned this aspect? Kindly see paragraph 8.
I've seen that. I appeared before the Supreme
No,
Court.
no,
I
why?
know.
Why it is saying that the
Because-
National
because
Highway
NHID
Authority, National Highway, the Infrastructure Development Authority, they also appeared in that matter.
Yes, my lords.
They say that we are not in a position, because now, by virtue of saying that this is a reserve forest, you go ahead with MORTH and go for this afforestation, and if getting certain amount, you then give it for land acquisition. No land acquisition, you will give it to the land, then they will make the roads. It is something to that effect.
For the compulsory afforestation, my lord, there is absolutely a different aspect, because it is nothing to do with the landholders. Because my humble submission, my lord, what I am saying from the very beginning, that they have got no right. They have got no right. They have got no title. It was a forest land. It was basically a forest land which was not given clearance to them, or no assent was given to them under Section 2 of the Forest Conservation Act by the central government, for them either to dwell or to use that particular land or have any right, title or ownership over that land. And until and unless that is there, they cannot do that. And for that I have placed reliance in the Honorable Supreme Court's judgment, my lord, which I have placed just now before your lordship. Thereafter, my lord, if I can come to the other aspects also.
Yes.
Lordship will kindly see paragraph 40 to 42 of the judgment of the learned single judge. My lords will see that just to regularize, it is my humble and respectful submission, my lords, that just to regularize the right of the occupants, this particular notification has been quashed. My lords will come to paragraph 40. A perusal of the notification dated 28th of January 1965, published in the Assam Gazette, dated 19th May 1965, reveals that the Chief Executive Officer, Mizo District Council, declared forests located within half a mile on either side of River Kurial and 15 other rivers to be council reserved forest. This notification was issued under Section 14, read with Section 21 of the Mizo District Forest Act 1955. However, it is noticed that before making the final notification under Section 21 of the said Act, no preliminary notification as required under Section 15 of the said Act quoted above was ever published in the official bulletin of the Council, Zoram Shiratnina. As such, the impugned notification cannot be accepted to be legally valid notification declaring the Turial riverine area as council reserve forest, where LSCs of the petitioners were used in favor of the petitioners for no fault of them or their misrepresentation of facts. Hence, the aforesaid impugned order dated 5th of August 2016, stating 5th of August 2016, my lord, the Chief Secretary's order cancelling the all LSC passes, stating that the lands of the petitioners are covered by the riverine reserve forest area is not sustainable. Now, my lords will kindly also come to paragraph 42. This contradiction which I have placed just now before your lordships with regard to annexure 8 of my additional affidavit. This is the part, this part of the judgment, my lord. That aspect has not at all been considered by the learned single judge. That this is the system which was prevalent. Now, my lords, whether the learned single judge was right in coming to the conclusion that this particular notification should be set aside and this land should be regularized. My lords, I rely on the Bombay High Court judgment 2013-3 MHLJ page 426.
Who relies? You are
I am
relying.
relying on.
Yes.
My lords will kindly come to paragraph 10, 11 and 12. Prior to that, if I can come to paragraph 9, just for the sake of this restriction on the de-reservation of forest, which has been mentioned. Page 428, my lords, paragraph 9. On this backdrop, it is necessary to construe the provisions of the Forest Conservation Act 1980. This act was enacted to provide for conservation of forests and for matters connected therewith or ancillary or incidental therewith. Essential conservation of forest is executive function. Section 2 of this act provides for restriction on de-reservation of forest or use of forest land for non-forest purpose, and thus regulates the executive function of the state in that regard. Section 2 of the Forest Conservation Act reads as follows. So that is there in the act itself, my lord. Now, my lord, if you can take your lordship, page 429, paragraph 10, 11 and 12. Grievance redressal mechanism in respect of a grievance occasioned as a result of directions under the foregoing provision of law was provided with incorporation of Section 2A of the said Act. If the provisions are read together, it is not difficult to perceive that the term other authority used in the phrase state government or other authority means and includes instrumentalities or agencies of the state government and that would not mean and include the courts, which has judicial functions to perform. Secondly, it is also necessary to understand what is regularization. Webster defines the term regular to mean conformable to a rule or methodical, thus making anything conformable to the rules by condoning any procedural irregularity can be understood as an act of regularization. This is certainly not the job of civil courts. Government resolutions in that regard are executive instructions to the state officials to act in a particular way as regards the subject matter of such government resolutions. Having understood the meaning of the aforesaid terms, it can be seen that the first question A, regarding the competency of the civil court to regularize the encroachment over forest land in the light of the provisions of the said act would not arise, as it is not the job of the civil court to regularize an encroachment, but to adjudicate the right of the parties making claim to any land, save and except the limitation on its jurisdiction, either expressed or implied. So that is what I was mentioning, my lord, that this particular regularization was done by setting aside and quashing the 1965 notification just for the purpose of regularizing the land which was held by the occupied by the encroachers, who had no right, title or interest over that land.
They may not have the right over the land,
Lordship.
but what about the standing crops? You have all along permitted.
My lords, yes.
The
If the
government
state,
of Mizoram have given us sanctity by acquiring the land. Thereupon, further, the DC does not do by himself. The DC would do only at the behest of the government.
my
Then the
lords,
government approves the awards. So, under such circumstances, they may not get any right in respect to the land. But what about the standing crops? Being a welfare state,
my lords,
they
may I
not be
reply?
entitled to?
My lords, may I reply? May I reply?
Yes, please.
May I reply, my lords? Lordship, ultimately, it is no doubt a forest land.
Huh?
Ultimately, it is a forest land, my lord. The forest land was used for non-forest purpose, for the purpose of
But you
construction of the
permitted
hydel
it.
project, and that is why it was acquired.
Therefore,
And,
let
and my lord, the compulsory afforestation was paid by NEPCO. But how can anybody use forest land which is not permissible under the law?
but you permitted it.
Lordship, if it has been permitted, it has been permitted without taking the sanction of the central government, which is again bad in law.
No, sanction of the central
I must
government
accept
and you see, this is as regards the LSCs. But if these people were there, even prior to the 1980 Act, if these people were there carrying out the cultivations and all in those forest lands, then whatever, and these aspects have been duly acknowledged by by the government.
Lordship, I do not disagree to that. But my humble submission, my respectful submission, my lord, is it something legal, something under the provisions of law which has happened, something which is relevant to the settled law as made by the Supreme Court? Has it been done according to that? Has it been done following the set provisions or following the settled law? That is my humble question, my lord. And thereafter, my lords will see that National Green Tribunal section 29. My lord will give me one. Section 29 of the National Green Tribunal Act 2010.
Yes.
I just want to draw your lordship's kind attention. I'm not, because my lords need to be aware that this matter is also pending before the NGT, and there was an order on 3rd of October also. My lords will see section 29. With effect from the date of establishment of the tribunal. Shall I proceed, my lord?
Yes, yes.
Of the tribunal under this act, no civil court shall have jurisdiction to entertain any appeal in respect of any matter which the tribunal is empowered to determine under its appellate jurisdiction. Number 2, no civil court shall have jurisdiction to settle, dispute, or entertain any question relating to any claim for granting any relief or compensation or restitution of property damaged or environment damage which may be adjudicated upon by the tribunal, and no injunction in respect of any action taken or to be taken by or before the tribunal in respect of the settlement of such dispute or any such claim for granting any relief or compensation or restitution of property damage or environment damage shall be granted by the civil court. So it is basically, my lord, although the Honorable Supreme Court has directed this Honorable Court to hear this matter out and order accordingly, my lord.
But Mr. Advocate General,
But
why
this-
are you referring to 29?
No, why I am referring to 29, my lords. This matter is pending before the NGT.
So
This matter-
what has happened to the judgment of the
I would just like
judges
to,
in El
I would
Chandra-
just like to keep your lordship informed about that.
This court has still the jurisdiction.
Absolutely, absolutely. But I don't want to suppress the fact. I want to bring it to your lordship knowledge that the matter is
Session of this
pending
matter-
before the NGT also.
No, you see, the aspect is the government has come up and passed some award.
My
The
lord.
government has passed an award in 2 cases, so in respect to the LSCs, okay, we will take care of that. But as regards the others, standing crops and all, whatever may be, isn't it the duty of the state to make some compensation for that? I
My lord,
understand.
if I am not
understand,
wrong,
maybe.
if I am not wrong,
You have all
and
along
subject-
allowed it. The
and
standing crops.
subject to correction, my lord, if I can say that that is something
Because one thing you see in your
which
forest
should be,
act, in the
which your
Bureau of
lordship
Forest
wants
Act-
the state to consider on humanitarian grounds,
Yes, that is the humanitarian ground.
No.
That is, in fact,
not on the point of law,
the 300A is a
not on the question
humanitarian
of law.
ground. Therefore, the Supreme Court says it is not only a constitutional right, it is also a human right.
My lords will see the judgment one after another, and your lordship is aware about the T.N. Udavarman's judgment and all the subsequent judgment based on that judgment. That hands of the state, the hands of the executive is tied. I have referred to all those judgments in my additional affidavits, my lord.
Sir, you should have then gone, why on earth did the government ask for going for acquisition? You wanted to acquire why? You acquired at the behest of at the behest of NEPCO. Where is the
On behalf
acquisition
of
notice?
NEP.
Where is the acquisition notice under section 4? No. Somewhere it will be there. Let us see what is being done. Because the section 4 notification cannot be issued without the government's concurrence.
Yes.
No, government's concurrence was there, well.
Understood? So
I
therefore, the government-
don't disagree to that.
you
It is
were
the
benevolent
government who
and
had
after
acquired the
20
land.
years- after
It is the
20
government who
years
had acquired the
down
land for
you know,
NEPCO. And NEPCO had paid for compensatory afforestation.
These people have been
That
fighting
remains,
all these years.
and that is why it is my humble submission that it's a forest land.
Understood, but you have maybe whatever may be, you should not have done that. But you have therefore taken note of that. Okay, we will give you certain amount as regards your standing crops. That is why you have made the award. You have not made the awards on the value of the land except two matters. All other cases you have only given as regards the standing crops. Now you see the reserve forest. To be a reserve forest, there are the various forests which is all put in the schedule to your Forest Act, which would come within the ambit of the forest produce. If it is outside that, and these are standing paddy, which is outside, then the government have taken a decision to make payment of compensation for them. You should have paid, you may have paid up, because 300A is not only as regards land, it includes any property also. So you have taken, okay, we will apply the Land Acquisition Act, the principles of the Land Acquisition, because you are not acquiring land. So the question of principles of the Land Acquisition Act has been applied. Let us assume that. You have taken 24.26 crores.
The
pay
nature of the
something.
land, my lord, the nature of the land remains unchanged. Whether it is acquired and whether it is used for non-forest purpose, the nature of the land remains as forest.
Yes, it is forest.
The nature does not change.
The nature does not change. It remains forest. It has been a forest. But just for example, tomorrow, if there are certain houses out there. Here some gold ornaments. Is the government going to say, oh, the gold ornaments are there in a house where it is in the reserve forest? The government should appropriate it. Something like that. Or should the Mizoram government be a benevolent government, say that, okay, as regards the government gold ornaments which are there, we are going to pay you those compensation for the gold, but not as regards the house or the building which you have done. This is absolutely illegal. Because, Mr. Advocate General, one thing one has to understand. If you want to start or go ahead with a land acquisition, you have to acquire the land and the benefits or anything attached to the land or anything to that effect, which is as per section 23. But here it was made clear that we are not going to pay you a single penny as regards the land, except in two cases where lessees were there. We are only going to give you as regards the Jirat. Just for example, in Assam, you find out where whoever is in occupation of the government lands, they are not paying. There are a lot of land acquisition going on for these national highway projects. They are not paid a single amount as regards the land value. But as regards the standing crop, they were having some coconut trees or whatever trees, whatever it is. So there some payments are being made. These are recognized principles. Because this is, after all, a property belonging to somebody.
Lord, I bow down to your lordship, and I do agree what your lordship is trying to.
Mr. Advocate
But
General,
the fact remains, my lord.
I have
But the
another
fact remains, my lord. Under what provision of law, the use of the forest land by persons or people who have no right over the said land, use of the forest land, is it legal? As per the settled law of the Supreme Court, is it legal?
Mr.
If
Advocate
it is
General,
not legal,
if it was a case,
how can the government give any
Mr.
compensation? for
Advocate
that?
General, if it is a case where some outsiders have come, I would have said, okay. You are also to take into account the history. Here, these are the people who were the natives out here. They have been all along out here. For them, it was not every place in Lusai Hills was a forest land. Till 1947, no law of the state of the government of India was made applicable in view of the 1935 Act. After 47 also, the laws were not so applied out there. So you have to understand, till T.N. Godavaran, which came up in 1996, and the expansion which is being happening from time to time till date, the forest produce. Earlier the forest produce, nobody thought that Zoom cultivation will be brought within forest produce. Now it is being done. So under such circumstances, all these aspects of the matter is now developing. These people did not know at that point of time. And that is what, in fact, that was also the knowledge of the year. That was also the opinion of the state. Otherwise, why would they have gone into the question of acquisition?
My lords will kindly appreciate the fact that that is why my additional affidavit goes way back to the year 1897, when even June cultivation was stopped for the purpose of the reserve forests. If I can take your lordship to the
Mr. Advocate General,
paragraphs, and to the documents which we
1891,
have
the British
annexed thereto
came.
from the state archive. Right away from 1897, my lords. My lords will kindly come to the relevant of my affidavit. Page 12, my lord. Paragraph 15.
Page?
Page 12, paragraph 15 onwards. I will take your lordships to the several note sheets and memos.
Where is that?
My lords will come to page 12, paragraph 15. And then I'll take you to the relevant annexures also. It is further submitted to the appellants that the available documents provide evidence of notification of the riverine reserve forest along with river banks, regulation of June cultivation, scientific forestry operations, and other protective measures before the year 1956, which are as follows. A note on the progress of the forest affairs within the Lushai Hills district, prepared by Superintendent of Lushai Hills during 1897, and the extracts from the note regarding the management of the forest along the navigable river banks is given below. As far as 1897, the Superintendent Lushai Hills agreed to restrict zooming along the river banks. Government's letter during 1901 to the Superintendent Lushai Hills proposed that Assam forest regulation should not apply to Lushai Hills and that the protection and control should be by an executive order of the Superintendent of Lushai Hills. Protection of the forests along the river banks of navigable rivers caused by far predominant activity. Deputy Ranger and Forester to be in charge of each river system to ensure marking before felling as well as supervision of felling of trees. The Superintendent Lushai Hills in letter number 820 dated 22nd May 1915, number 318, recommended for continuing of control of forests along navigable rivers more carefully. Conservator's letter number K/133 dated Silchar the 14th June 1915 proposed coops up the navigable rivers with the control by the divisional forest officer. My lords will kindly come to Annexure 4, page 85 onwards. Lordship will see that this control is way back from 1897. Page onwards, my lord. If my lords allow me, I can read it.
Annexure 4,
Page 85 onwards, ma'am. A short note on the progress. I'm sorry.
Yes.
A short note on the progress of Forest Affairs within the Lushai Hills districts, and on account of the position at the proposed that's illegible, together with a summary of the conditions and sanctions governing the control of forest villages within the Lushai area, Lushai Inner Line Reserve. Therefore, my lord, there is a big note of the superintendent which goes on up to page page 100. This is a very important and relevant document, which again, and page 101 also, which was again collected from the Mizoram State Archives. And this reflects and clearly shows that how zooming was restricted and how the forest was protected, the reserve forest and inland line forest was protected way back in 1897. 1956 or 65 is far away, but that restriction was very much there from 1897 itself. If my lords permit me, I can read it out. It's a 17 pages note.
Is a judgment?
No, my lords.
This seems to be a judgment at page 90. That is the finding.
Page 90.
This seems to be a judgment that he has given a history.
He has given a long note. M.L. Scott, 20th February 2023. It's an order. Rather, it's an order.
This was the judgment, I suppose.
It's an order, yes. That how these reserve forests were protected even way back during the 19th century.
And prior to this 1955 Act or 53 Act, what was the power, under what power it was made reserve?
Finals, again, we have to go back pre-independence time. That is the note sheets and orders which I was just referring to. And thereafter also, my lords will
That
see.
is not an order, a note sheet. It is actually an order passed by then the superintendent, DC or superintendent then, imposing a penalty or something.
Something for violation.
Yeah. But what
For
was
violation
the
of
power
the
at that point
restriction.
of time? Prior
But
to
order, my lords, will kindly come to annexure, will kindly come to page 102. 102. It's a bit illegible, but the type copy is there in 102A. There is a riverine river. Effect of enforcement on the Chakma population of Lungle subdivision. Thereafter, copy of DO letter, page 103, copy of DO letter number 45C, dated 18th of January 52, from Secretary Tribal Affairs, Tribal Areas and Development Department to the Superintendent. Type copy is there in page 103A. That is regarding the Chakma population in the Lungle area. Then again,
So you have paid 50%. Somebody got 50%, no?
my lords,
Somebody got 50% of the award. Some parties got 50% of the award.
yes, my lord, 50%.
And rest 50% is where? With whom? NEPCO or government?
NEPCO has paid 24.46 crores as afforestation.
Understood. So 50%.
Now
has
thereafter,
been
my
paid.
lords,
And rest
after the
rest-
cancellation of the LSEs,
No, Mr.
and not only that,
Rest
your lordship,
50%
your
is
lordship
with
may
whom?
be aware that there was a CBI investigation also pertaining to this.
No, no, CBI is only for those persons who were the officials who made these land acquisition awards, not for those people.
No, not only officials, my lord.
But I'm asking
Not only
you,
officials.
with whom is the remaining 50%?
I will have to
Monday.
take instruction. It's
Monday
a long,
letter-
it's a long,
Monday-
it's a long,
Mr. Advocate General, I think you have completed your submissions.
more or less,
Yes. We will hear the petition on Monday.
more or less. But one aspect. If your lordship kindly give me 5 minutes, 5 minutes more.
Yes, yes.
My lords will kindly come to page 107. That is a very relevant memo number. Way back 5th March 1949. The type copy is there in page 107A to the subdivisional officer Lungle. I have the honor to report that some local chiefs and karbaris are always approaching me to have a clear idea about in Lushai Hills, on which I could not make any reply. As this office has not been supplied with a map of reserve forest of Lushai Hills, I have been failed to come to any conclusion on this. I would therefore request you to kindly provide me a map of showing extent and boundary of reserve forest, or to forward general instruction as to what extent I should observe was reserve forest to protect from zooming. I notice on some occasion some local people cutting zoom by the riverside. I stop them from doing so, finding that the forests are going to lose its beauty, and bamboo and trees of other species, though not of so good quality, are going to be destroyed by this, soliciting an immediate reply. So, my lords, from way back in 1949, this restriction was there, and the concept was there that forest land should be protected, the forest should be protected, irrespective of whether, my lord, at that time
There is no question that the forest should be protected.
Forest Act,
Mr. Advocate General, half of Aizawl, if we go by your statement, and another statement, half of Aizawl should also go. Because this was also, half of Aizawl was also forest at that point of time. Let us not go into that. But the question is, where is the power to make it reserved? I understand from 53. Earlier to that, where? So let us constrict ourselves to 56. Now,
No,
the
again-
question therefore
again,
is,
my lord,
Mr.
my lord,
Advocate
I
General,
will
we
again-
will request you one thing, get your instructions as regards the remaining amount. Something is to be done.
remaining
whatever may
amount,
be-
my lord, I have to take instruction. I
That is
don't-
what, Monday.
Frankly,
Monday,
because I was not,
Monday, you just take your instructions on that As regards with the remaining amount, 50% has been paid. This court is not going to say that that amount to be taken away. No. What about the remaining amounts? Because if you go by the afforestation policy also, the question is how much you have invested, how many trees you have imposed. Now, after taking that 24 crores is another aspect. That is why
That aspect is
that is why Mr.
that is a
Jindal
different
has
aspect,
paid-
Melo. That is a different aspect. That's an admitted fact. That 24 crores has been paid by NEPCO.
But whether it has been put to use,
Definitely for the purpose which has been taken, it has definitely been put to use.
where?
That, my lord, I cannot.
Why these
find
additional
that now.
affidavits are
I
not
have to
clear on
find out. I
that?
have to find out that.
If you have received this 24.66, then
46.
in that case, why the additional affidavits or none of the documents are clear on this aspect? What have you done? Mr. Jindal is saying that, okay, we have paid this 24.66, we have nothing to do. And if you are receiving this afforestation concept came only after the T.N. Godavaran's 2012 or 2002 judgment order, and then you have this afforestation rules, how it is to be appropriated, that amount. Anyways, think about this welfare state. Something is to be
We come
done.
back on Monday.
Monday.
Lordship, Lordship,
Mr. Advocate
Lordship.
Not in fact, on Monday,
you
on
kindly
Monday I had a
get this-
different matter.
Huh?
Lordship,
On
Lordship,
Monday I had a different matter in Sikkim High Court on Monday and Tuesday. So can it be taken up after the
We'll take it as the first item, Monday.
Lordship,
first item?
Lordship,
Yeah.
may I request, Lordship, I'm not available on Monday, if it can be taken on Tuesday.
Oh, Mr. Jindal, you see, the
I
question is,
humbly request your
the question
Lordship,
is, you have not challenged the award. You have already, your question is that there was certain directions where the contempt direction was also to the that the court said that we are not going to say this is between the state and the NEPCO, but the state has to pay. That is your submissions. We'll take care of it. Don't worry on that. But I am only concerned how something can be done to that effect. We'll hear the petitioner side on that day, more particularly on the question of delay. Because delay is an impact which needs to be looked into. Because it is after almost 35 and another 10 years. Around 45 years, the writ petition was filed challenging this notification. We'll hear the petitioner on that and what rights have happened. In the meantime, Mr. Advocate General, kindly find out.
And not only that, my lord.
Yes.
From the time of the acquisition of this particular land and all the litigations, nowhere, at no point of time, this 1965 Act has been, this 1965 notification has been challenged.
Yes, the
This
counsel
was
for the
this
petitioner
was
kindly
taken up.
show me
This
on the
was taken
next
up
day
by the learned single judge.
your
This was
section
taken up by the
4,
learned single judge
The-
just to regularize the occupants.
the orders pertaining to these notifications under section 4 or 6.
If the lower court records, if the honorable single judge's records are called for,
No, we are not going to call. You have a photocopy of that, produce it. No calling for those. Call for reports.
they are all annexures in the writ petition.
It's there. I just want a 4 and 6. Have a look at it. Hearing
Lordship.
remained inconclusive. The
We will
matter
keep it
to be
on the
taken
top
up
of the
again
board, my
on
lord.
Monday at 10:30 a.m. as the first item.
I am deeply obliged.